Good morning, good morning, good morning, amazing Leonard. Today we have the Murdacity among us. It is Tuesday, it's July 9th. Replay crew, as always, love you, good to see you. Timestamps will be down below, though lately they've been taking a little bit of time to populate. So if you are like immediate replay crew, give it a second, they'll be back. It's been taking a bit. Everything's been taking a bit. The technology has been technology-ing. But it's all good because today we are talking about the Alec Murdaugh of it all. But we're not talking about the Murdaugh murder of it all. We are talking about Murdaugh versus Courthouse Becky. And what is fascinating to me about this case is that it's going to be real interesting to see how this plays out when just everybody's wrong. Like, I have no love lost for either of the parties in this lawsuit, but I still want to see how it plays out. And also, I think it's a really good exercise in Murdaugh can be wrong, but he can be right in this instance. Like what Courthouse Becky did is not correct, but it's really interesting to look at a case where you're looking at everybody going, great, good for you. But I'm real interested because today we're looking at Courthouse Becky's audacity in her motion to dismiss. And then we're looking at Murdaugh's clapback, which is a clapback, and all of the lawyer sass. The lawyers are sassy. The lawyers are feeling sassy. I think the lawyers have learned, like the sassier the writing, the more we enjoy reading it. It's a 10. But Courthouse Becky, we talked about this a little bit in a podcast and I promised a deep dive and then everything popped off everywhere else. And I'm like, but Courthouse Becky is claiming immunity. And it's not even like TikTok immunity. She's claiming like actual immunity from her fuckery. And I can't wait to see what Murdaugh has to say. And if you are not caught up on the Murdaugh civil side, we've got some little tidbits that we need to talk about. We've got some little juicy nuggets that we're going to chat about. So, Leonards, are you ready? Let me know where you're coming in from, what you're drinking. Good to see you. I'm not yet done with the coffee. I have not read the entirety. We've gone through an overview, but we have not gone through a deep dive in Courthouse Becky's motion to dismiss. And I have not looked at Alec Murdaugh's opposition to the motion to dismiss, except like the first paragraph. And I was like, oh, okay. So I'm ready. I hope you're ready. It's good to see you. Also, I'm just going to let you know that past Emily was way more optimistic about everything I could accomplish today. And somehow I have a flight tomorrow morning that boards at like 5:15. So if it feels like Emily's in warp speed today, that's why. I don't know what I was thinking. I don't know what past Emily was thinking. I don't know what. Sure, girl. Sure. Cheers. It's going to be one of those nights where I have to manually input my sleep in Pokemon Sleep so I can cheat because there's no way we're getting enough sleep to even log it on Pokemon Sleep. What else were we doing today? This morning, Sum 41. I think we're going to have to just put a like playlist out of a what's on my current playlist and just update it frequently. I think that's a need. But Sum 41, if you have not heard Sum 41, I did it for the Dopamine. It's off of their newer album. If you're familiar with like the Fat Lip era, yes and I did it for the Dopamine is like the ADHD theme song of my life. So I did it for the Dopamine, Sum 41, A Place for My Head, Linkin Park, which was a song I had completely forgot about. And then Travis was just like, have you heard this song? And I was like, oh, I'm living for this. I love that my kids have either found new music through their algorithm that I had not found, or have like reinvigorated a love for music that I had forgotten. Because there was a moment when Travis was like, Mom, have you heard of this band, The Sick Puppies? I'm like, child, I was around when it happened. Are you going to tell me about Pennywise next? Because I was there, but I'm enjoying that you're enjoying it. Let's listen to music together. I love it so much. So, Sum 41 did it for the dopamine, amongst others. Linkin Park, Place for My Head. What else was this morning? More Bad Religion. More Bad Religion. That's where we're at today. And there was some System of a Down in there too. There was definitely some toxicity this morning. So that's where we're at. Law Nerds, it's good to see you. We're going to roll the intro. I'm going to give you some tea on where we're at with the civil case. Then we're going to fly to South Carolina. Are we ready? How hot is it in South Carolina, South Carolinians? How hot is it? Purple Prickly Pear, Descendants fan. I grew up in the South Bay. The Descendants are mandatory. Also, Dr. B. Things you might not know about Dr. B. These are the things we discuss on members only. Things you might know about Dr. B. Or not know about Dr. B. Dr. B graduated high school a bit before I did. But Dr. B was a dyed hair in the sink, metal toe boot wearing, underground club going, punk scene dude. I know, punk rock dentist. Dr. B is a harder punk than I'm punk. I'm 90s pop punk. He's 80s break your nose at a show punk. Dr. B at one point tried to go orange hair and it went very pink. But Dr. B is punk. Laughed at me when I'm I kind of love The Offspring. He's like, girl, have you listened to X? We'll find some pictures. But Dr. B can talk about his punk days. That he has a story about his punk concert jacket that someone stole and the heartbreak that still ensues. Julie in the chat, same year. You and Dr. B, same. So Dr. B though also grew up doing FFA because he grew up in farmland, California, more than the beach cities, California. So we have some fun stories. But yes. Thank you. William knows. Yes, William. Someone did steal his battle jacket. It's a long story. He is still not recovered. He's still mad, and I get it. I'd be mad too. But we'll talk about it. So Dr. B still had dyed hair going into dental school. And I just related so much because he and I both struggled with how much of our authentic, why is that hard to say back to back? Our authentic weirdo selves are too much in our professions. And so I think that's one of the things, in addition to being very neurospicy, but I think it's one of the things that we both connected with so much is that there's this other side of you. And then when you're going into a profession, my parents weren't lawyers, his parents weren't dentists. We're going into a profession where we're kind of first of the people that we know going into a profession. And so you feel like you kind of have to overdo it a little bit into that profession. And you're not quite sure what your professional persona is versus real life persona. And then at some point you grow up and you're yeah, I don't give a fuck. But when you're young and newer in your profession, you're I want to be taken seriously. I do not want to be judged about anything else. And so that was something that we related about very early on in our relationship. So, and then as I went forward, I was just you know what? There's room to be a professional person and a full human. And there's a balance to that. But also, there's a little bit of easy for all these people to say who've grown up with all their parents in X profession. And law and dentistry are very like that there's lineages to them. So it was fun. But it was also something I learned about. There was a defense attorney who I was offended at the time, but later on I was like, this was some of the best advice I received. I was in misdemeanor court in my like black suit with a skirt, pearls, the whole 9 yards, like newscaster haircut, which in hindsight, a short haircut that I couldn't pull back in a bun was maybe not the best plan. But either way. And he was like, girl, like the pearls are a bit much. And I'm like, I am very professionally lawyerly. Very professionally lawyerly. Leave me and my pearls alone. And later on, I was like, I mean, I'm ready for like some handcuff earrings. Like, what are we doing? That's probably too much too. We'll find a balance. And then after I, herniated my back and then again, and then had knee surgery and the rest of it, I was like, who are we kidding? We're not wearing 4-inch heels to work anymore. This isn't Ally McBeal. You've got to be joking me. Like what we're not doing. Right. Good morning, law nerds. Are we welcome to talk about Murdaugh? Are we ready to talk about Murdaugh? I think so. Let's roll the intro. Let's spill some tea. It's good to see everybody. It's good to see that where all of you graduated from high school and some of you were like, but I wasn't born yet. It's okay. You're welcome here. Welcome to the safe space with your elders. We've got you because what we all want for you, for those of you who are like, I wasn't born yet. What we all want for you is to have a shortcut past all the stuff we learned the hard way. We still want there to be some friction, play old video games, but we want to shortcut all the bullshit that we learned the hard way and help you get there quicker. And just be yourself. Because really, at the end of the day, it's the best way to be happy. Even when shit's hard. Ready? All right. Let us go. It's good to see you, law nerds. Happy Thursday. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening, no law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I mean, some of you for members only remember my story of trauma and woe when my docs got stolen in college. Right. I did leave them outside my dorm room because they were wet and a little stinky because I wore them to the Hobart Hoedown, but that was totally my bad. But also, like, come on. What are we doing? It's a dorm. Ugh, rude. Let's talk a little bit of tea. Remember, Alec Murdaugh is pending murder trial in South Carolina after the South Carolina Supreme Court overturned his case. And though Corey Richard's defense attorneys would love to make that ruling about something else, it's not. That case got overturned because of Courthouse Becky. That's why it got overturned. And when you look at that ruling, they pretty much excoriate Courthouse Becky's bullshit. But in addition to that, Alec Murdaugh also sued Courthouse Becky for violation of rights, essentially, depriving him of a right to a fair trial by interfering with the jury. And I see chat talking about what's Jenny's number, 8675309. We know this. We know this, chat. I had to close the loop in my brain and say it out loud for y'all. And Jenny can't lose that number because we all remember. So, Courthouse Becky gets sued by Murdaugh for the deprivation of rights. This is in federal court. Karen Reed is suing Proctor et al. For deprivation of rights in a different way. Deprivation of rights because of the investigation, etc. We've got Murdaugh suing Courthouse Becky for deprivation of rights for interceding with the jury. And one of the things with deprivation of right, as Murdaugh is suing, is that Becky is an official, state actor. She is an elected official. So she filed an answer and filed a motion to dismiss. We're going to look at the motion to dismiss today. But this case got assigned to Judge Gergel, Gergel. I don't know how else you would pronounce that. I would try to go with Gergel, but it's Gergel. It's just, that's how it's spelled. I don't know. What else do we do? It is what it is. So this federal judge, if you remember, is the federal judge that sentenced Alec Murdaugh in his federal case. And not only did he sentence Alec Murdaugh, but he did something that so many judges will not do. He basically told Alec Murdaugh that stealing from clients is the lowest of the low and that he is a scourge of the profession. But also, he sentenced Alec Murdaugh 10 years more than what the federal prosecutors asked for. And it's his right to do that. But it is rare to see a federal judge sentence a defendant to more than prosecutors asked for in the first place, and to sentence to more than the prosecutors asked for on a white-collar crime, on a non-violent crime. The judge had very strong feelings, clearly, about stealing from clients, as all lawyers, I think, should and do. But I did a lot of fraud cases. I really liked fraud prosecution. I did a lot of fraud cases. And I was constantly fighting with judges about the harm done to the victims. And anyone who's dealt with identity theft or dealt with wide-ranging fraud knows that there is a lot of trauma that goes with it. There is recovery that goes with it. There is expense that goes with it. And it can be absolutely devastating. And I spent a lot of time arguing that. So I felt kind of vindicated watching the judge be like, no, done. But now you've got Murdaugh suing Courthouse Becky, and the same judge is assigned. And I can't wait to see what happens with that because, well, I think that Murdaugh's team is sitting there looking at the judge going, well, you were kind of mad about my abuse of a position of power. Let's see what you're going to do with Courthouse Becky. Because I don't think you're going to love her abuse of state office. This judge clearly looked at what Murdaugh was doing and said during sentencing, this is not how you treat a position of power and trust. And I wonder if Murdaugh's lawyers are sitting there going, oh, well, you're going to love what Courthouse Becky's up to. So no, they've never asked for another judge. I think Murdaugh's team is looking at this going, you know what? This judge does not love this group of behavior. And we're the ones suing this time, and he's not going to love that. So I think that's why we didn't see Murdaugh's team having an issue with it. I think Murdaugh's team thinks that this is going to go well for them with this judge. And if they trust that this judge knows the law and is smart, then that's what you want. Because, well, if you're Murdaugh versus Courthouse Becky, you want a judge that's going to get it. And you want a judge that's going to be like, no, we're not doing this. Go to your deposition, get your discovery done. You want a judge that's going to hold people to their obligations. And I am very interested to see it. Also, what's going to happen when we get to Courthouse Becky being like, but I need a Murdaugh deposition, because Murdaugh is still pending another criminal trial. It's going to be real interesting to see how this all goes down while the criminal trial is ongoing. I'm real interested. So, Jazzy Jazz said, isn't there a max limit of time a judge can sentence someone for fraud? Yes. The judge did not hit the maximum with Murdaugh, but it depends. Murdaugh had a whole bunch of charges and a lot of money. And so in the federal system, it goes up based on how many charges and how much money. So there was more time that he could have been charged for. Neuropsych said fraud can be emotionally devastating. 100%. 100%. And we've talked about it a couple times, but 100%. Jessa shared in the chat, this woman defrauded her gramps out of $200K, and now the chargebacks are hitting people she bought from. Yep. I'm not surprised by that. We're going to have to talk about another chargeback case because we have not circled back in the Erica Girardi realm, talking of fraudster lawyers, Tom Girardi. We'll get there on another day. We also have to say a huge, huge thank you for gifted memberships. Thank you. Let me find it so I can grab it because I absolutely lost it in the chat. I just had it. And then it disappeared, but I don't know how it disappeared. Cindy, thank you for the 50 gifted memberships. I don't know where it went. I went to go pull it up and it is missing, which is so strange. The tech is just not letting us be great. But Cindy, thank you so much for the 50 gifted memberships. Thank you. I don't know. I'll pull it up again in a second, but thank you. And welcome to all the new members. That's incredibly generous. And I appreciate it. And we will find it. So thank you. Now that we've talked about the T on Judge Gergel, and a lot of you said that's how Eric Bland and Mandy Matney, I trust their pronunciations over mine. And if that's how they're pronouncing it, then I feel like I'm in good company. And huzzah. Cooper, thank you so much. I can't talk about it much more, but thank you so much for the well wishes. I appreciate it. It was a long weekend. We will talk about it at another time when I can. Thank you though, in the chat for your well wishes. I appreciate it. Lawnards, are we ready to fly to South Carolina? Are we ready? I think we shall. Murdacity. Let's Murdacity, shall we? We're going to look at Courthouse Becky's motion to dismiss first. And we are going to go, sure, Jan. We'll do that. Someone asked, didn't we already fly? No, we introed, but we did not fly. And if we did fly, it is completely gone from my mind. And we're getting double miles. So either way, we're flying again. All right. Courthouse Becky's motion to dismiss. This was filed June 18th. We talked about it very briefly on the podcast. And I think I said, or at least in my brain, I was thinking that I wanted to cover this and was going to wait until we saw the response from Murdaugh. That was filed July 7th. So we are covering this together with Murdaugh's response because that was just filed. So that's the grouping on these. And with the Murdaugh, that was filed on July 2nd. With the Murdaugh civil stuff, I'm going to try to group things together in groupings of filings because there's going to be more happening in the criminal case. And then there's been Massachusetts as this whole fucking multiverse. So it's going to take sometimes a minute. I also think this is going to go slower because of the criminal case pending. So that's the point. All right. Plaintiff. Motion to dismiss. 2. Plaintiff. Richard Alexander Murdaugh. And yes, chat, I understand that if his name is Richard, in the words of Peter Mon, if his name is Richard, then his nickname would be Dick. I understand. However, it's so close. It's so close to the name calling. And also, his attorney's name is Dick Poot. So we can't have everybody be dicks. They can't all be, yes, Emily, they can't all be dicks. They can't all be dicks. It'll just get confusing. Murdaugh. Plaintiff Richard Alexander Murdaugh Sr. by and through his counsel. You will please take notice. God, South Carolina has some legal quirks that I just really enjoy. I don't know. What do you guys like better? Comes now or will you please take notice? Will you please take notice is just so polite. It's just so polite. And I find it incredibly polite. Hold on. Emily's Emily's feeling spicy. Give me 30 seconds. But yeah, you let me know what you like better. Comes now, or will you please take notice? The defendant, by and through the undersigned counsel, respectfully moves this court to dismiss plaintiff's complaint for failure to state a claim upon which relief can be granted, or for this court's lack of subject matter jurisdiction pursuant to Rules 12b-6 and or Rules 12b-1. Y'all have been around long enough to know that your 12b-6 motion to dismiss for failure to state a claim generally doesn't get granted. And if they do, I have rarely seen them granted without leave to amend. There are very narrow circumstances where the court will say, I am granting the motion to dismiss with prejudice. You do not have leave to amend. A 12b-6 failure to state a claim is just on the four corners of the document. Does this document, as pled, not say a thing that is a cause of action? It is a pretty easy hurdle to overcome for defendants. And then lack of subject matter jurisdiction under 12b-1. I'm interested to see what her arguments are there. Defendant moves pursuant to Rule 12b-6 of the Federal Rules of Civil Procedure for dismissal of plaintiff's suit based upon plaintiff's failure to state a claim for relief. This is the area we talked about a little on the podcast. I think it's an interesting argument as we get there. I'm curious to see what the court does because I do think it's an interesting argument because they've nuanced it a little bit more than just nothing is wrong here. Plaintiff alleges, in short, that defendant's actions deprived him of an impartial jury and that he is, therefore, entitled to recover the full sum of money thus spent on his criminal defense. Okay, first of all, he. We have pronoun problems again so early in this motion. Entitled to recover the full sum of money thus spent on his criminal defense trial. Such damages, they say, fall outside the scope of 42 U.S.C. 1983 and 1988. Those are the code sections here. So, can the relief that he is requesting, recouping the cost for the criminal trial, can that relief be granted? And I do think that that's an interesting question. Do you get back the cost? They say that the Fourth Circuit has never established that damages stemming from the legal costs associated with defending an underlying criminal case are redressable under the statute. Hey, nobody says the cost to defend a trial, which is your choice, is something that you can get relief for. I think it is an interesting question. It is a nuanced question. I think the taxpayers of South Carolina should be able to sue Courthouse Becky for the millions they invariably spent the first trial and now are going to have to spend again. But I digress. Because Courthouse Becky has cost so much money. However, I find myself wanting to put a little footnote that I am not terribly fluffed about whether Alec Murdaugh has to pay for another criminal trial or not. It is an interesting legal question. They go on to say, to the extent that other circuits have considered the question, they, along with the Fourth Circuit, have been clear that in the event such damages are recoverable, a plaintiff must show that his damages were caused by the defendant's actions. Such cannot be the case here, where the entirety of the economic damages claimed by the plaintiff would have been spent on his criminal defense, regardless of any actions taken by this defendant. Again, I think this is a really interesting question, because what Courthouse Becky is arguing is that You had to defend trial number 1 no matter what. And it's premature to ask for damages for trial number 2 because it hasn't happened yet. The money hasn't been spent. You can't get prospective damages in the future. And trial number 1, you would have spent that money either way. So it's not damages. You can't show that you had to spend more money on this trial because of Courthouse Becky. You have to spend the money on trial number 2, but that hasn't happened yet. And so the part 2 of the argument is if there are damages for paying for trial 2, well, that's premature and you have no actual damages. And one of the things we see often in food court when we do see motions to dismiss granted is one of the things that the judges rely on is that there's no actual damage. That's what happened in that, remember that Velveeta case where somebody was suing because the box said like ready in 2 minutes or 3 minutes or whatever the period of time was. And the argument was, well, I had to put water in the ready mac and cheese and then I had to microwave it and then I had to let it cool. But I had to microwave it for the amount of time on the box. The box said ready in 3 minutes, but it's not ready in 3 minutes because I have to put water in it and then I have to let it cool and that's more than 3 minutes. And the court was like, you're not damaged. Shoo. There's no damages. There's nothing for the court to redress. Get out. Right. We do see this in food court and no damages tends to be the thing that courts will kick the cases out on. So it's now really interesting to see a nuanced argument on no damages. And I mean, is Courthouse Becky wrong? It's an interesting argument. They go on to say that for much the same reasons, defendant, Courthouse Becky, is entitled to dismissal of plaintiff's claims pursuant to Rule 12b1 of the Federal Rules of Criminal Procedure, where the compensatory damages sought by the plaintiff are not traceable to defendant's actions. Finally, to the extent, if any, we've sidestepped the what, if any. At least there's that. To the extent, if any, that plaintiff argues otherwise that inconsistent with his complaint, he seeks damages related to the second future trial, defendant likewise moves to dismiss plaintiff's complaint under Rule 12b1 of the FRCP under such theory. Plaintiff's damages have not and indeed might not ever accrue, and plaintiff's suit would therefore not be ripe for adjudication, divesting this court of jurisdiction to entertain the same. I'm not mad at the writing. And I think that's an eloquent way of saying it would be premature. It would not be ripe at this time because the damages haven't occurred yet. Finally, and most critically, even if plaintiff states a compensable claim, a tort of some type, defendant is nonetheless entitled to 11th Amendment immunity, quasi-judicial immunity, and qualified immunity, all of which bars plaintiff's suit. So no damages, throw the case out. Then we get to immunity. So now that we've gone through the notice, let's get into the memorandum of law in support of the motion to dismiss. I love the overview, though. I think the notice was a great overview. I appreciate when the notice is like, this is what we're arguing. And now we're going to put a little bit more meat on the bone. Let's see. The entire first page is exactly what we just read in the notice. So we're going to go to standard of review first. Defendant moves to dismiss plaintiff's complaint under Rule 12b6 and 12b1. A Rule 12b6 motion examines whether plaintiff has stated a claim upon which relief can be granted. Like everyone who's studied law everywhere will say this in their sleep. The same way they will never buy anything called Green Acre or Black Acre. But failure to state a claim upon which relief can be granted is like written into your memory. They say that the United States Supreme Court has made clear under Rule 8 of the FRCP, which is Federal Rules of Civil Procedure. I will abbreviate it thusly to avoid saying all of the words. The complaint must contain sufficient factual matter accepted as true to state a claim that is plausible on its face. However, a claim is facially plausible when the factual content allows the court to reasonably infer that the defendant is liable for the misconduct alleged. When considering a motion to dismiss, the court must accept as true all the factual allegations. We know it's everything taken in the light most favorable to the non-moving party, Murdaugh. The court must also consider documents, or may also consider documents attached to the complaint. Yes, yes. The fundamentals of standing are well known and firmly rooted in American constitutional law. To establish Article 3 standing, a plaintiff must identify an injury that he suffered that can be fairly traced to the defendant's conduct, and that will likely be rectified by the relief the plaintiff seeks. And that part is where Courthouse Becky is hinging a lot of her claims. Can it be rectified? Argument. Plaintiff alleges during the course of his criminal trial for the murders of his wife and son, which began January 23rd, 2023. Has it been so long ago? Which began on January 23rd, 2023 and ended March 2nd, 2023. Defendant Becky Hill had multiple improper contacts with and made multiple improper prejudicial comments to the jury. They're saying that's his allegation. Plaintiff brings the instant civil matter under 1983, seeking to recover compensatory damages, so compensation, compensatory damages for defendants' alleged constitutional violations of Murdaugh's Sixth Amendment right to a fair trial by an impartial jury secured by the 14th Amendment. Plaintiff seeks compensatory damages in the amount of $600,000, which represents the flat fee paid to plaintiff's legal defense team, a combination of attorneys from Griffin Humphreys and Richard A. Harpootlian, PA, for their work in his underlying state criminal trial. Plaintiff does not contend defendant's alleged constitutional violation of Murdaugh's Sixth Amendment right to a fair trial by an impartial jury secured against the states by the 14th Amendment caused plaintiff to incur the additional legal cost of defending any post-trial and appellate litigation or future retrial. And here's the thing. In a murder case, if there's a conviction, there is going to necessarily be appellate work no matter what. So the fight is, were any of these costs caused by and related to Courthouse Becky's behavior? And I do think that that's a really interesting question, because he chose to have private representation. And I imagine that Alec Murdaugh paid this amount well before a jury was ever selected. I think I'm real curious what we're going to learn in deposition about when these monies were paid, lest we forget that there are many other civil things going on for Murdaugh, and there's been suits with insurance and suits with families of victims, et cetera, et cetera, et cetera. So when he paid these lawyers and where that money came from is something I'm interested in, but undoubtedly this amount was paid well in advance of a jury being selected. And if it's before a jury is selected, then is that cost directly connected to what Courthouse Becky did? Fair question. Fair question. Honestly, I think I'd rather see Courthouse Becky have to pay back the taxpayers. Unless the money for Alec Murdaugh goes back to his victims, I'm just not as pressed about whether his attorneys get this money back. If it went directly into his restitution, I might feel differently. I feel more strongly about the South Carolina taxpayers and all the money that they spent because of Courthouse Becky's fuckery with trial number 2. But I digress. When the outcome is one of those things where I'm like, I'm just curious, I'm not really invested deeply either way, I find it easier to explore the nuanced, interesting legal arguments, because I guess we'll just see what happens. I'm curious how the law works out on this one. I'm curious. So, Sunny Day in the chat said, isn't the injury Becky sabotaging the first trial? That is what they are alleging she did. But can you be compensated for it? Because the money he spent in the first trial, he spent before Courthouse Becky interceded in the case at all. So is that money tied to what Courthouse Becky did? And they are arguing it's not, because that was money he would have paid for the first trial, whether she did anything or not. And that's true. If Courthouse Becky didn't exist in this whole scenario, Murdaugh was still paying his lawyers that amount of money. So it's not money that he was paying because of what Courthouse Becky did. And Afraid said, but now he has to pay for the second trial. Fair. His lawyers said that he's not, though. And if he's suing, which he's not, but if he were suing for the cost of the second trial, that question's not ripe yet because he hasn't paid it yet and the second trial hasn't happened yet, which means this lawsuit's too early and then it gets dismissed and you have to wait. That's where the quandary is, because the cost of the second trial hasn't happened yet. So it becomes, I say premature, but it becomes, it's not ripe yet. And his lawyers did say in the media, Jim Griffin said repeatedly, and let's just side note for a second, every time the cost of the second trial comes up, Poot looks at Griffin and is like, Jim, care to explain? And Jim says, well, we were hired to do a job and the job hasn't been done yet. So we are still doing the job for the cost of the first trial. So I think that Murdaugh might be in a little bit of a pickle, like the baseball sense, where if he doesn't have the money at this moment to pay for the second trial, which I think might be true, and the lawyers are not charging him more for the second trial, which might be true, they can't sue to recoup the cost of the second trial if Murdaugh doesn't pay for a second trial. And Courthouse Becky's alleging that the cost of the first trial is something that Murdaugh pays no matter what. Courthouse Becky's actions didn't cause him to be prosecuted for murder. And on any murder, Murdaugh's not arguing that the cost of appeal is different because of Courthouse Becky, because any murder conviction, you're going to have an appeal, no matter what that appeal's based on. So truly, the harm then becomes the cost of the second trial. But the cost of the second trial is not recoverable if he doesn't pay for a second trial because he paid for the first one. But if the cost of the first trial is not harm that Courthouse Becky caused, then he can't recover it. And then he's stuck in the middle. And then what do you do? And I think that's a really, really interesting question. Because then, well, you're kind of stuck. So, Figgy Compass said, question, if a trial is overturned like here, does the person who paid for the trial get a refund? No. The lawyers still did the work. So, no, the lawyers do not get, well, in that context, lawyers are not paid for the result. Lawyers are paid for the work done, and the lawyers still did all the work. So, no, they do not. So, it's a really, really interesting quandary. E. Heigl asked, can the lawyers sue her for the cost of the second trial? No, because it hasn't happened yet. It's prospective. Can they go back and sue her for the cost of the second trial? If it comes out of their own pockets, we would have an interesting standing issue. Yeah, because you have to recover your cost, your actual cost, which is where we see the food court cases getting thrown out of court with the, you're not harmed. There's no amount of money that can fix the harm here. So Murdaugh's kind of it's created a legal quagmire that I'm curious about. So let's continue. I'm not dismissing these arguments out of hand. I think they are actually very interesting arguments. I mean, all of you are asking, the second question is, can she ever pay this? Not our problem for today. Not our problem for today. Can she ever pay it? I don't know. Recovery is always a separate issue. Is the TikTok psychic ever going to pay the professor? I mean, recovery is always a second issue. But who knows? I mean, not to be somewhat grim about it, but who knows? Courthouse Becky could come into an inheritance tomorrow that they could then attach. You never, ever know. Or Courthouse Becky could sue someone else and recover a bunch of money. She could, walk down the aisles at Piggly Wiggly and slip on a puddle of water and sue the Piggly Wiggly and come into a settlement that they could then go after. You never know. You never know. So, continuing on into our legal quagmire that actually presents some, I think, really interesting legal questions. This would be a fascinating law school exam that would also make everyone crazy because I don't know what the answer is. The court is really going to have to go through this, but this creates a if this then that might just be a circle with no answer. So, did and can Murdaugh actually recover? They go on in header 1 saying the foundational principles, 1983's remedial provision, bar plaintiff's recovery of legal defense fees incurred in connection with his underlying state criminal trial. Plaintiff's suit is based upon a novel theory of liability and recovery. They say, to the undersigned counsel's knowledge, this is a case of first impression, meaning this has never happened before. Well, Murdaugh's the gift that keeps on giving, because a lot of the things in Murdaugh have never happened before. This is a brilliant way. Emily, what does case of first impression mean? Well, it's a legal term of art. What would the law nerd definition be? This fuckery has not before been seen. This fuckery is unknown to us. This is a brand new level of fuckery. Look at that. Fascinating. It's rare these days that we get brand new levels of fuckery. I think with technology changing, we're gonna see some new and novel levels of fuckery. But as technology changes, they always use analogous technology. So as stuff changed with TV broadcast, they went back to radio broadcast. And when things were growing with radio broadcast, they went back to newspaper distribution, et cetera, et cetera. But this is really an interesting question of first impression. So, no federal circuit or district court has addressed the question of whether a criminal defendant who alleges their Sixth Amendment right to an impartial jury has been violated can recover damages for the legal defense fees incurred in connection with the underlying state criminal proceeding in a subsequent civil suit brought pursuant to 1983. So interesting. Even expanding this inquiry beyond, they say, the narrow scope of the Sixth Amendment, the Fourth Circuit has never directly addressed whether a 1983 plaintiff, quote, can recover attorney's fees incurred in connection with an underlying state criminal proceeding. And that is a 2015 case that they're citing, and a 2022 case that they're citing. The Fourth Circuit is where South Carolina sits. We talked about the circuits a little bit when we were talking about Utah, and I was just like, why are we citing New Jersey when Utah is not the same circuit? And the numbering of the circuit goes East Coast to West Coast. So roughly, the lower numbered circuits are going to be your East Coast, and then it moves across the country. So we're looking at Fourth Circuit. They go on to say, absent such guiding law, remember, law always looks at what other judges have done. among the age-old principle of judges, don't be weird. Don't do anything weird. What did the judges before us say? Great. I agree with them. Do that. Law is not about reinventing the wheel. It's about saying what happened before, how does that apply here? Absent such guiding law, defendant turns to general principles upon which 1983 remedies are based and to other circuits' treatment of plaintiff's theory of liability. This is actually an appropriate instance to take a look at what other circuits have done because there is no law within the Fourth Circuit. So then you look outside the circuit. What have other courts done elsewhere? Little Reese, it is not at all. Little Reese says, is it bad that I really hope that they find against Becky just because I want her to be an example to anyone in the future who contemplates jury tampering? It is not bad to want Courthouse Becky to get their comeuppance. I just think that her comeuppance needs to make sure that it is legally proper. And I don't know if this nuanced and narrow question is the comeuppance. I wanted her to get prosecuted more. I think the best way to remind someone that this fuckery shall not stand is to put them in jail for a bit. Politicians escape jail way too easily. And yes, she's an elected official. I think she should have been held accountable by a bit of jail time. I understand that she has probation. I just think if we're going to make an example of people who really fuck up, people who abuse positions of trust and power should be at the top of the list of those who should be made an example of. I have a tier list. Abusing positions of trust and power is at the top of my tier list. Make an example out of her. And then make her pay back the taxpayers of South Carolina. So I agree. I don't know if this is the proper vehicle for Becca Boo to get her comeuppance. I am fairly confident that the humiliation of this has probably been devastating to Becca Boo. Is that enough for me? No. No, it's not. No, it's not. No, it's not. It's not. Your embarrassment is not enough for me. So, you know, it is where it is. I am frustrated. I understand the quandary they were in, but I'm frustrated they didn't go after her more for jury tampering. She didn't even get yelled at enough by Justice Toll. I hope that someday, maybe at the same Piggly Wiggly, she just runs in to our favorite judge, right? Well, one of our favorite judges. We have many favorites. There's no limit.
Bring the jury.
I hope that one day she just runs into Judge Newman and he just, Emily, we're creating fanfic. Yep. In Emily's world of karmic justice, just a little bit, runs into Judge Newman down at the Piggly Wiggly and he just takes a look and is like, how could you? And just walks away. Can you imagine? Can you imagine? How could you? And walks away. Because you know he's thought it. You know he's thought it. Yep. So continuing on. This is I'm vibing with the lawyers here. To the point, really clear. I mean, yes, there was a typo. Who am I to complain about a typo? But yes, there is a typo. But we are following a very clear legal format. We are citing law that is relevant. We are walking through the explanation in a very logical format. Vibes. We are just like, okay, there's no law in our circuit. This is actually the proper time to look at other circuits and be like, hey, other courts, have you ever had to wrestle with this problem? How do you deal with it? And then you keep going through it. And that's the appropriate time to look outside your circuit. And the lawyer explained why. And I appreciate that too. Defendant turns to the general principles upon which 1983 remedies are based and what other courts have done. The Supreme Court noted, quote, or they say, quote, repeatedly noted that 1983 creates a species of tort liability. And that is coming from a 1986 case. As such, the common law of torts provides the appropriate starting point for the damages inquiry. Again, they are citing all of this from case law. The general purpose of damages under 1983 is to, quote, and they've bolded it, emphasis added, compensate persons for injuries that are caused by the deprivation of constitutional rights. Again, this is also what we're seeing Karen Reed sue for with malicious prosecution and conspiracy, etc., in her federal case. They say that deterrence is also an important purpose of this system, but it operates through the mechanism of damages that are compensatory, damages grounded in determinations of plaintiff's actual losses. That doesn't say attorney's fees. This law is not written to put money into the attorney's pockets. But what is the damage? Wait a sec. Where is it? What is the damage to Alec Murdaugh?
Emotional damage.
Thank you, Stephen He. What is the damage to Alec Murdaugh?
Damage refers to harm or injury.
No.
It can also refer to the negative effects of something on a person or thing. In law, damage refers to money required to be paid as compensation for an injury or wrong. This answer is from TheContentAuthority.com and TheFreeDictionary.com.
I didn't ask you. Cancel. I didn't ask you. Did I wake you up? Did I rub your lamp? Did I bring you here? I didn't do it. I wasn't asking you. I was asking chat. You're not chat. Apparently, my device would like to be a part of the show today and had much to say on my rhetorical question. Yes. So, getting back to me. They are talking about whether attorney's fees count here. They go on to say, like the common law tort claims upon which this code of the U.S. law are modeled, claims brought pursuant to 1983 require, quote, but for and proximate cause analysis. But for analysis is literally that. This, but for that. So it's real easy in like a car accident example, because if your car is working perfectly fine and then somebody runs into it, your car was perfectly fine, but for someone running into it. And so it's pretty easy to say, well, it was perfectly fine before, and then you hit it, and now this is the damages. It's real easy to look at through that lens. But the but-for analysis is, this happened, and now I have to pay this money. I am damaged in this way because of the thing that you did. And I would have been fine, but for what you did. And so Courthouse Becky is saying, there's no but for here. You got charged with murder based on your own shit. I didn't go prosecute you for murder. Different in the Karen Reed example, right? But Courthouse Becky's like, I didn't prosecute you for murder. I was the clerk of court. All of this happened before I was even involved. So your legal fees are not because of me. So I don't owe you any damages. Legal D said, practicing for almost 10 years and I still giggle at the but for arguments. 100%. Because what's a but for? 100%. 100%. So Murdaugh, the argument, At bottom. Today's the perfect time to use that phrase. At bottom, the argument is you had to go to trial anyway. So it is not on me, your legal fees. It is a very good question. And I think the court is going to grapple with this quite a bit because you have a point. And I think a fairly strong point, truly. The other analysis is proximate cause. Are you responsible? They go on to highlight examples of that, saying that 1983, quote, should be read against the background of tort liability that makes a man responsible for the natural consequences of his actions. Easy in a vehicle collision analysis. The Supreme Court has instructed, quote, in order to further the purpose of 1983, the rules governing compensation for injuries caused by the deprivation of constitutional rights should be tailored to the interest protected by those particular right in question, just as the common law rules of damages themselves were defined by the interest protected in the various branches of tort law. Ordinarily, then, the compensation awarded under a provision, under a proven constitutional violation is governed by the interest it's intended to protect by the right, the constitutional right, and by the damages foreseeably stemming from that right's violation. So all of you, then we get back to, well, the foreseeable cost then is a second trial, not the cost of the first trial. In the instant case, however, plaintiff prays for damages consisting of the entire cost of the underlying criminal trial, during the course of which plaintiff alleges the defendant violated his Sixth Amendment right. The Fourth Circuit has never recognized 1983 as a countenancing, I think, has never recognized 1983 as countenancing such a broad grant of damages. And these circuits, and those circuits that have addressed the issue have predominantly rejected such an approach. So this circuit's never addressed it. Circuits that have addressed it have said, you don't go here. Federal circuits are split as to whether 1983 permits recovery of legal fees incurred during an underlying state criminal proceeding. There is a split of authorities, which is also interesting. There is a split of authorities on the issue of whether a criminal defendant whose constitutional rights have been violated in an underlying state criminal proceeding can recover damages for incarceration, legal costs, fees, or
emotional damage.
They say emotional distress, but emotional damages. They go on to cite a New York case from 1999 that found that they were going to bar the recovery of attorney's fees and costs incurred in an underlying criminal proceeding where evidence for gun possession charges arose from a violation of the Fourth Amendment, which was probably like an illegal search. There's another 1988 case that they are saying the Ninth Circuit recognized recovery of money spent on legal representation for the defense of the underlying, on legal representations. It's an odd sentence. Legal representations defense of underlying acquitted criminal charges as compensatory damages for economic harm. So the Ninth Circuit has said yes. It seems that other circuits have said no. Emily, what do you do with a circuit split? Well, this circuit's going to have a really interesting time trying to decide what happens. And then no matter what the judge does here, it sounds like it's kind of ripe for appeal then. And maybe ultimately for Supreme Court review. Because, man, it's really interesting. They go on to say that defendant first addresses the Second Circuit's approach, that the Second Circuit has rejected 1983 compensatory damages relating to a individual's conviction and incarceration stemming from a Fourth Amendment violation. even though it was brought, not in this context exactly. They say that the Second Circuit panel first held that the fruit of the poisonous tree doctrine, affectionately called FOPT by me and probably many others, FOPT. We're doing all the law school things today, but they are saying that the fruit of the poisonous tree doctrine cannot link the unreasonable seizure and search to the conviction and incarceration because this evidentiary doctrine is inapplicable to civil 1983 crimes. Fruit of the poisonous tree, just briefly, because we love learning new things. Fruit of the poisonous tree is where you get to thing A illegally, and then thing A leads you to thing B and thing C, but all of it is fruit of the poisonous tree because thing A was illegal. It's kind of like gossip. Like if you shouldn't know the thing at the beginning, everything that stems from it is stuff you shouldn't know because you shouldn't know the thing at the beginning. Kind of. It's a really bad game of constitutional violation telephone. There's a world of doctrine around fruit of the poisonous tree. We talked about this a lot with the Chrisleys and the OG Chrisley prosecution because the court had ruled out quite a lot of evidence for a Fourth Amendment violation, and then a subsequent court was like, that's fine. Continuing, right? So you shouldn't have even been there. You shouldn't have even been there, and then you learn all these subsequent things that you shouldn't have known because you shouldn't have been at thing A. So they're talking about this in the context of fruit of the poisonous tree because I don't think this question of interfering with a jury from a state actor has ever come up in this way. They say that the Second Circuit also found that a plaintiff's incarceration was not proximately caused by the alleged Fourth Amendment violation. The panel determined that the unconstitutional seizure and search of the defendant in that case's person was not a proximate cause of his conviction because of the trial court's refusal to suppress the evidence was an intervening and superseding cause of the conviction. That's interesting. Do you see the nuance there? It wasn't the illegal seizure that was the problem. It was the court allowing that evidence in that was the problem. And that intervening ruling by the court cuts off the liability for the original harm. Because if the court had ruled differently, then it would have been kept out, no harm, no foul. Not our situation here. Hopefully you don't mind if we skip forward to their next argument, because they are trying to look at analogous case law, but there's nothing really squarely on point. And we're going to have to wait to see if the court has argument on this, which will be really interesting, which if the court does have argument on this, won't be televised because federal court. But please, can we just put cameras in our courts so we have transparency? Also, because we really want to watch this unfold in court. Thanks. But we're going to move on because though I find the legal nuances of this interesting, I think for our purpose, the takeaway from this part of their argument is there aren't things squarely on point. The court has not allowed compensation of attorney's fees under this type of a claim. And this court has never looked at this type of claim before. For all of you that are like, I want to do a deeper dive into the nuance of this, I will upload this on Scribd and then post a link so you guys can read it afterwards. And then in the lounge, you guys will have access to it to download. But I'll post it on Scribd so everybody can read it. For those of you that are like, I'm actually really interested in the fruit of the poisonous tree analysis, I'll put it up for you guys to read. They go through what the Ninth Circuit found and where the Ninth Circuit allowed some attorney's fees compensation. Let's see. Let's get to their next point on that. They went through the Third and Seventh Circuits. So numerous circuits, more circuits saying that attorney's fees are not recoverable in this type of claim. They say that the court should adopt the Second Circuit's rationale barring recovery of legal fees incurred during an underlying state criminal proceeding in a subsequent 1983 action. So they're asking the court to adopt the methodology of analysis that is most friendly to them. Of course they are. Let's see. They do a pretty thorough analysis. I actually really like the way that the lawyers are marching through this. I think it's, well, organized, linear, and helpful. Accordingly, defendant urges this court to adopt the rationale set forth in the Towns case that they were talking about above, that we moved through, when analyzing the two dispositive questions before it. One, whether defendant's alleged constitutional violation caused the attorney's fees incurred by plaintiff in connection with his underlying criminal trial. And two, whether awarding damages to compensate plaintiff for the cost of defending the underlying criminal trial would be tailored to the interest protected by the Sixth Amendment right to trial by impartial jury. And then there's a footnote 1. I think that the way they've framed it, if you ask yourself that question, is Becky's alleged violation here, and I might not say alleged because we saw what the Supreme Court said, is Becky's bullshit the cause of Alec Murdaugh's attorney's fees in trial number 1? No, because her fuckery didn't even come into play until late into the trial. So if the court frames it that way, Becky's lawyers, we're not crediting Becky with this, Becky's lawyers have done a really good job of framing the question to the court in a way where the logical answer is no. And then they go to the second question, is this what the law contemplates? And that's where footnote 1 is. While defendant acknowledges common law torts serve as a starting point for the analysis under 1983, defendant is unaware of any existing common law analogs. And so they're saying, look, there's nothing in case law, but there's also nothing in common law. Like, what are we doing here? Their next point is that there's no causal connection between defendant's alleged constitutional violation, Becky's, and the attorney's fees incurred by plaintiff in his underlying criminal trial. So the first thing was, hey, does the law allow for this kind of damage? The next question is, hey, is she the cause? So this is that proximate cause analysis. Her argument is that plaintiff is not entitled to recovery of his expenditures for legal representation in his underlying criminal proceeding. Plaintiff asserts that he, quote, funded his murder trial defense with a $600,000 withdrawal from his 401k retirement funds. I would like to point out that the only reason that Alec Murdaugh was able to put $600,000 into his 401k retirement fund is because he was stealing money everywhere fucking else. So the money that was going into his retirement fund was from his paycheck because he was using all the other money for fucking everything else. And so his retirement fund went to him for his legal fees and didn't get yoinked to go to his victims because it came from his paychecks. Imagine if your entire paycheck could go to savings because you're getting money elsewhere for everything else. Oh, how lovely would that be? It makes me so mad. It makes me so mad. But this money, because a receivership was put into place, in the receivership, when the court evaluated this, he was allowed to use his entire 401k to pay for his lawyers. I know. How mad. Right. Agreed. So he paid his $600,000 from his 401k, which was his, quote, sole remaining asset. They say that initially the, quote, loss of such attorney's fees may constitute monetary harm potentially compensable under 1983. And then they're citing a case law that says compensatory damages may encompass, quote, out-of-pocket loss and other monetary harms. Plaintiff, however, has failed to feasibly allege that defendant's action caused the funds to be lost. I can understand this argument. Because he's not spending this money if he doesn't get arrested, and he's not getting arrested because of Courthouse Becky. Her lawyers go on to argue that he cannot recover damages here because the injury he pleads does not fit the damages he seeks. Defendant's alleged constitutional violation was neither the but-for or proximate cause of plaintiff's underlying criminal trial. This is very different than the Fourth Amendment violations, because the Fourth Amendment violations are dealing with searches and seizures, generally of evidence that's then going to be used in a criminal case. So that's all coming before you get charged. This is happening midway or late through the trial. And so it's a very different fact pattern here that his criminal prosecution has nothing to do with Courthouse Becky. Tony, good to see you. I'm going to home show. Tony, can I just say real quick before you bounce? Chat, Tony was saying bye. Tony, can I just tell you real quick before you bounce? Cavaliers got rained out again yesterday. It's their fourth scored run that got rained out so far this season. I don't know what I'm going to do. So hopefully the weather is clear this weekend for home show and I get to see my kiddo perform. So I'm hoping everybody, fingers crossed for some clear weather, because they've had 2 scored runs and their perk has been scoring amazing. And I still haven't gotten to see a full run of Crown yet, but I'm going to go watch it on Funliner later because I'm pretty sure it's up. Do they have makeups? No, they don't. The Midwest tour is getting just thwarted by the weather, and like Blue Coats and Vanguard are running around with like all their scored runs under their belts. So I'm hoping that we get to see a scored run this weekend, but hopefully we'll talk. I'll see you on the road. I'm excited. Also, everyone who asked about yesterday's rabbit hole real quick. No, all good from yesterday. And actually Funliner commented on the video yesterday and I was so excited to see it. And we just had a little like, yay, commentary smile. So Funliner was excited that we had talked about the show and his video a bit yesterday. I was excited that we got to talk about it. So it was all good, all excitement. I was really happy to share it with you. And that's why everything's time-stamped. So people who are like, girl, law talk, less music talk. Right. Fair. It's time-stamped. But also the music talk makes my heart smile, which allows me to do all of the law talk. Because sometimes we need to fill the heart up. So, the argument from Courthouse Becky is that the plaintiff's criminal trial did not, quote, hinge entirely on defendant's alleged constitutional violation. To be fair, Murdaugh's criminal trial did not hinge at all on Courthouse Becky. His criminal trial was completely to the side of it. Tara in the chat said, speaking of music talk, I did watch Hamilton last night. It did not disappoint. I'm so glad. The cleverness of Lin-Manuel Miranda is unmatched. I am constantly in awe of how his brain works. I am in awe of the performers and how they can do it. I love the way it's put together, but I love the cleverness. I love it so much. I also love the absolute dedication of, I'm interested in this thing because I'm very ADHD. So I'm interested in this thing. And then we might come back to it 6 years later. But the dedication of, I'm interested in this thing. I'm going to learn everything about this thing. And then I'm going to put it into music and tell the story and also weave in multiple perspectives of that story and banger music. It's brilliance. And I love the writing. I love the cleverness. I'm in awe of the work of art that it is. in awe. There is so much I love about it. Every time I pull out something different, I love it so much. Emily, we're shocked that you love cleverness and good writing. Yes, I'm in awe of those that are gifted in that way. This goes on to say that, can you imagine if Lin-Manuel Miranda started taking on writing some of these legal pleadings? Oh my God. Would his sassy footnotes not be top tier? Can you imagine? Top tier sassy footnotes. It would be fantastic. All right. I understand their argument here. Murdaugh's trial is not because of Courthouse Becky's alleged constitutional violation. The prosecution and the state chose to charge him on the evidence that they had, completely aside from anything Courthouse Becky did. I get it. They're citing case law that also agrees in different circumstances with that, including case law where the Fourth Amendment violations are there. So then they go on to argue that the injury here, the legal fees, do not stem from what Courthouse Becky did. Their summary of this section is that defendant requests the court to dismiss Murdaugh's complaint under 12b-6 because defendant's alleged constitutional violation did not contribute to the attorney's fees incurred. I don't disagree. Becky interfering with the jury did not contribute to the attorney's fees incurred by plaintiff in his underlying criminal trial. Irrefutably, whether defendant acted improperly or tampered with the jury or not, the plaintiff was in either event going to face a verdict of guilty or not guilty from the jury. Accordingly, whether guilty or not, the plaintiff would have most certainly incurred the exact same amount of attorney's fees he now seeks to recover from the defendant as damages. I don't disagree. Honestly, I think if this gets to discovery, it will bear out that Murdaugh paid them $600,000 well in advance of this case ever picking a jury. Yeah, I don't disagree. I'm curious to see what Murdaugh's team, maybe Poot will sway me. I'm real curious to how they respond to this. They say because defendant's conduct could not have caused these damages, defendant is entitled to dismissal. Am I going to agree with Courthouse Becky in this? I might. They go on to say that a damages award compensating plaintiff for the cost of his underlying criminal trial would not be tailored to the interest protected by the Sixth Amendment right to an impartial jury. I'm going to skip the law that they cite because I'm not unpersuaded in their arguments here, but I appreciate how thoroughly they're walking through the different branches of the same argument. Emily, these all feel analogous. They're different branches of the same argument. And also, I'll just, for my own comfort, I think Courthouse Becky's lawyers are doing a great job in this motion. So really, it's agreeing with her lawyers, not her. We're getting to their summary. Let's see. We're going to go to their summary only as they summarize the case law. They say that in the instant matter, no Sixth Amendment interest would have been furthered by allowing plaintiff to reap financial benefit in addition to being afforded a new trial. A partial jury undermines the integrity of the verdict by poisoning the sanctity of the evidentiary process. I like that turn of phrase. It's a fairly strong turn of phrase. An influenced jury here, but a partial jury undermines the integrity of the verdict by poisoning the sanctity of the evidentiary process with outside influence and bias, thus betraying the people's faith in the fairness of the criminal justice system. Agreed, and for that she should pay. I just don't know if this is going to be the vehicle for it to happen. To ensure the integrity of the verdict, the remedy for an impartial jury is a new trial, not an acquittal. This is because the evil of a partial jury is not that it injures the petitioner, but rather that it taints the legitimacy of the verdict, which impacts both parties in the adversarial process equally. Interesting. And betrays the public's confidence in our criminal justice system. See South Carolina versus Murdaugh. Oh, they're pulling a little inspo from the Supreme Court. And then they quote the Supreme Court saying, both the state and Murdaugh's defense skillfully presented their cases to the jury. However, their efforts were in vain because the right to a fair trial by an impartial jury was denied. Excuse me. Team Richens? That's the court's holding. That's the court's holding. Right there. That. Plaintiff acknowledges in his complaint that he was awarded the proper remedy of a new trial as the result of a Reamer and harmless error analysis. That's case law that they're citing there. This remedy wholly compensates plaintiff for any alleged constitutional violation of his right to an impartial jury. And the very purpose of granting a new trial is to protect the interest of fairness by ensuring the integrity of the jury's verdict. The policy justifications underlying the Reamer court, the harmless error doctrine, and the Sixth Amendment would not be served by letting plaintiff continue to benefit from those doctrines. It's an interesting argument that the remedy... Emily, no. I don't remember all the lyrics to Remedy. Melody, yes. Lyrics, no. But the remedy here, they're arguing, is the new trial. And they're saying that not just Murdaugh's harmed, but the state is harmed. And to that, when I say the state is harmed, yeah, the prosecution now has to go through another trial, but the taxpayers have to pay for it. So, y'all are harmed. Do y'all think we could convince Attorney Tom? Because Attorney Tom and Josh, who's America's attorney, they do a lot of class actions. I wonder if there would, I need to ask them. I need to ask attorneys that know more about class actions than I do, if there would be a right for the taxpayers' class action against Courthouse Becky, because I'm real curious. That's a question I need to ask. I'm real curious. Emily, do you just want this to happen? Yes. I feel like that's the proper remedy. Even if it cannot be recovered, I think it's important to see if that's possible. I'm going to ask. I'm so curious. Lisa says, you mean the really short Attorney Tom? Yeah. I heard he's shorter than Banfield. I've actually met Attorney Tom. It's for those of you who are like, Emily, what are you talking about? It's a joke. It's a joke with Attorney Tom is a very tall human. I've met Attorney Tom in person. It's a joke. It's a joke. There's deep lore there. We'll talk about it another day. I'm real curious. I'm going to be texting after this. It's funny because last time Josh and I had gotten together. He was in Nashville for something else. We got together and Tom was calling Josh. And I was like, wait, is that Tom? And he's like, yes. I'm like, let me answer the phone. I'm like, hey, Tom. And he's like, huh? I'm like, it's Emily. He's like, what? And I'm like, no, you called Josh. We were at breakfast. He's like, what is happening? Right. Sorry. We're just chatting. So this is a different branch of the tree of the argument that there is no damages. And if there's no damages, yeet. Plaintiff cannot recover damages for the legal defense fees incurred in connection with his underlying state criminal trial under 1988. So now they are looking at a different combination of the law and also saying that there is no language that allows for attorney's fees. Their argument is real simple. We're going to cover the first paragraph of this. Plaintiff additionally seeks to recover attorney's fees under 14 U.S.C. 1988. 1988 provides, quote, in any action or proceeding to enforce a provision of sections 1977, 1978, 1979. I'm not just rattling off your birth years, chat. These are the laws. 1977, 1978, 1979, 1980, 1981. I mean, all great birth years, though. Of the revised statutes, 1981 through 1983, 1985, and 1986. I'm not rattling off your graduation years either. Those are all the 42 USC sections. The court, in its discretion, may allow the prevailing party a reasonable attorney's fees as part of the costs. So they are quoting the statute that says, if you bring a suit under any of these sections, including 1984, and you win, you can get attorney's fees for having to sue. So let's use an analogy from another case we're covering, right? We're covering Karen Reed's federal case, Karen Reed suing Tully, Buchanan, Proctor, McCabe, Albert et al. Higgins. If Karen Reed wins that civil suit for deprivation of rights, this section says, and then you may recover attorney's fees for needing to bring that lawsuit. So not the attorney's fees for the criminal prosecution, the attorney's fees for the deprivation of rights lawsuit. Does that make sense? And so the lawyers are saying, look, the reasonable attorney's fees are for this litigation, not for the past litigation. To the extent that plaintiff alternatively attempts to recover the $600,000 spent on his criminal defense fees and costs under 1988, defendant submits those damages are not recoverable. Okay. They go through their analysis of the case law from a variety of circuits to support their argument that those code sections do not allow attorney's fees for the underlying case. They go on to say that plaintiff's claims for compensation damages must be dismissed for lack of subject matter jurisdiction because he lacks Article 3 standing. Article 3, jurisdiction, lack of jurisdiction. Article 3 of the United States Constitution grants this court the judicial power to resolve cases and controversies. Federal courts have the constitutional authority to decide and pronounce a judgment and carry it into effect between persons and parties who bring a case before it for decision. Cases and controversies. It has to be an active case. They go on to say that the doctrine of standing honors the limitations inherent in the assignment by ensuring judges attend to actual harms rather than abstract grievances. This is not like, hey man, can you settle an argument for us? This is, you have been harmed. We can rectify the harm. And in civil, that's with money. But if there's no way to rectify the harm, if there's no relief to be granted, then there's no case in controversy. And this is how those food court cases have gotten yeeted. Like I think the Reese's one got yeeted for no damages too. The Reese's that was suing over whether or not like the Reese's pumpkins had jack-o'-lantern faces cut out on them or were just full chocolate. That one, I think it also got thrown out for no damages. Because the individual's like, well, I wouldn't have bought the Reese's. It's like, okay, so your compensation is $3.95 for your pumpkin Reese's. That's under the federal threshold. Go to small claims court. So they're arguing here that because there's no way to compensate for the damage, there is no case in controversy, therefore there's no standing. This is the exact argument that the food cases get yeeted on. Their next point on that is that plaintiff cannot establish his claimed injuries are fairly traceable to defendant's conduct. Again, similar argument, different branch of the thought process. They're covering all their bases. It's their motion to dismiss. Because what happens if they get dismissed here? Well, reversing what I said earlier, if they get dismissed here, there is a possibility if the court finds no standing that it could get dismissed with prejudice because the court could find there is no way on these facts at this time that Murdaugh could ever recover, no matter how he pleads this case, could ever recover that $600,000. So when you are throwing a case out for lack of standing, there is a possibility that the court can say it doesn't matter what you say. You cannot, as a matter of law, recover for those $600,000. So come back when there's a case in controversy. That dismissing this case with prejudice, I don't think would preclude Murdaugh from suing after the second trial. But then he would have to pay for the second trial, wouldn't he? And that doesn't seem to be happening. So this is actually a really interesting argument that the reason they are going well and truly into all of the different branches of argument is because I think Courthouse Becky's lawyers see an avenue where this case could get dismissed, possibly with prejudice, because the court could find as a matter of law, this cannot be compensated. So that's why we're seeing similar arguments on different branches. It's incredibly linear and logical. So they are also giving kind of the arguendo in this argument, saying, to prove defendant's alleged constitutional violation caused plaintiff to lose $600,000 in attorney's fees, plaintiff Murdaugh must submit evidence revealing but for defendant Becky's actions, he would not have incurred $600,000 in attorney's fees. Fair. In other words, plaintiff must demonstrate that but for Becky's alleged constitutional violation, his underlying criminal trial and his attorney's work therein would not have continued for this 11-day period. And they are talking about that period because they are saying that plaintiff's murder trial lasted a total of 40 days. They say this in an above paragraph that I had zoomed. Plaintiff contends defendant's alleged constitutional violation began 29 days after the trial began on February 21st and continued for 11 days until the sentencing. So they were saying, fine, even if we can splice it to the time that Becky's alleged to have said the first thing to the jury about this that was improper, then it's only a very small window of time. And they say that then Murdaugh must prove that during that 11-day period, Murdaugh incurred more attorney's fees because of what Becky did. Here's the problem. Do you see the problem, chat? They didn't know. And they argue it in their motion for new trial. In their motion for new trial, because they made their first motion for new trial, it got denied. Then they made a subsequent motion for new trial based on newly discovered evidence. And they argued before the court in that second motion for new trial based on newly discovered evidence that they had no idea. And so they had to petition the court to be able to argue that there was newly discovered evidence and they should be allowed a second bite at the apple on the motion for new trial. Scotty didn't know. Scotty didn't know. Scotty didn't know. Don't tell Scotty. So now we have a problem of judicial estoppel. Because you can't argue before one court, we had no idea. Let us have a motion for new trial based on newly discovered arguments, and then go into another court and say, well, we knew during that 11-day period of time. You're kind of estopped. Because I think the truth is that they didn't know until later. They didn't find out. So what work would his attorneys have done because of Courthouse Becky during those 11 days? The same work they were going to do anyway, because they were in a murder trial and Scotty didn't know. Ooh. Rock versus hard spot on this one. Courthouse Becky's attorneys, I think, have done a pretty good job of posing a legitimate quandary. They say that they would have to narrow it down to that 11-day period. And any evidence in support of the contention that during those 11 days, the attorneys had to do more because of Becky, they say it would be highly speculative guesswork. Y'all should go back and quote his motion for new trial based on newly discovered evidence. They say even if the court were to accept this speculative theory of recovery, the relief requested wherein the complaint herein is far beyond any actual cost of attorney's fees incurred. At first blush, and by way of simple estimation, it factually appears that plaintiff could only show he incurred $165,000 in attorney's fees in his underlying criminal trial, even possibly related to the defendant's alleged constitutional violation. I think he's stopped from making that argument, honestly. Assuming plaintiff's complaint is a true reflection of the attorney's fees incurred in the underlying criminal trial, and assuming arguendo, there it is, that his attorneys were paid only for the days upon which the plaintiff was on trial, footnote 2, we'll get there, plaintiff incurred $15,000 in attorney's fees for each day of the 40 days that he was on trial. Yeah, no. That $600,000 was paid well before trial and covered what it covered. I think they probably spent $100,000 on housing, staying in Colleton County. Footnote 2, while undersigned counsel submits that it is safe to assume that the work for which plaintiff's defense lawyers were being paid began well before the January 23rd trial date, for the purposes of this motion to dismiss, defendant assumes arguendo. So I'm not saying it's true, but for the purpose of argument, if the court finds this fact, then this argument, that the date of the first payment was January 23rd, 2023. I think this was paid well in advance of trial. Defendant only makes this assumption at the current state of the proceedings because the discovery process is not yet developed. Defendant will, of course, update the accuracy of these calculations upon plaintiff's provision of evidence demonstrating the date upon which payment began. I want to know. And then they go through their calculations of if $600,000 was just for the days of trials, just for attorney's fees, because I think some of that $600,000 probably went to experts. I don't know if all $600,000 went to just attorney's fees. I think some of it probably went to housing. We'll see. But they're parsing it down to say it couldn't be the full $600,000. So they're putting their less impactful arguments down at the bottom. And then they get to the ripeness doctrine. Hey, if Murdaugh argues that he's entitled to the cost for the second trial, it's not ripe yet. It's not a controversy yet. It hasn't happened yet. It hasn't been paid yet. So we can't look forward. We can't borrow tomorrow's troubles into court. That's a tomorrow problem. Come talk to me after it's happened. Court deals with things that have passed, not things that may happen in the future. It's why courts are so hesitant with regard to things like injunctions, because injunctions are one of those rare circumstances when you are trying to stop something that may happen in the future. That is not what courts like to do. Courts are like, tell me everything that happened. We'll sort it out afterwards. It's why I think courts should be cautious about things like injunctions. All right. So, ripeness, we talked about ripeness. They're going through the case law analysis on it. We are not for our purposes today. I think we all understand what ripeness means. Not ready yet. It's not cooked. It's premature. Defendant is entitled to immunity. Defendant Courthouse Becky argues at the very end. Do you see the ordering of the arguments? Things that the court is going to take more notice of, and then to the end. The end is like, oh, by the way, if none of that works, immunity. This is the oh, by the way argument. Defendant is entitled to immunity under the 11th Amendment and under the doctrine of judicial immunity and qualified immunity. They say that if this court finds that plaintiff's complaint is not subject to dismissal based on the above arguments, then what? Then they say Courthouse Becky is entitled to immunity. Okay. Plaintiff alleges defendant is a constitutional officer of the state of South Carolina, elected as the clerk of court by the citizens of Colton County, and that the actions taken by defendant were taken within her official role. Similarly, defendant is entitled to quasi-judicial immunity, where the actions complained of by the plaintiff were judicial in nature and related directly to the defendant's judicial responsibilities. I've not seen this extend beyond judges. I'm curious to see if Murdaugh will spend more of his motion attacking this than the other arguments. I'm curious. Also, talking to the jurors about the case are specifically prohibited by her role, so it's not as if she was acting in her proper capacity. But I bet they'll argue that, because this is the easier argument for them to attack, I think, than the others. The others are more difficult. I think at the end of the day, I'm going to be disappointed if the court doesn't take this up, because the other arguments are more persuasive. And the court's like, we don't need to get to this question. We don't even need to talk about this question. They say defendant is entitled to qualified immunity where it was not clearly established at the time of the alleged constitutional violations that defendant's actions violated plaintiff's right under the Sixth Amendment. As plaintiff alleges in his complaint, former Chief Justice Jean Toll denied plaintiff's motion for a new trial, finding that defendant's conduct amounted to harmless error. The South Carolina Supreme Court reversed the decision, acknowledging throughout its opinion the difficulty, the complexity, and the conflicting jurisprudence in the Sixth Amendment inquiry. The violative nature of defendant's conduct then, or violative, was neither readily apparent nor obvious to the former Chief Justice Toll nor the South Carolina Supreme Court. It could but have been wholly lost on defendant or any other reasonable clerk of court. Defendant is entitled to immunity under the 11th Amendment. The 11th Amendment of the Constitution of the United States establishes that judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state. Okay. But the Supreme Court has consistently held, they say, that that an unconsenting state is immune from suits brought in federal courts by her own citizens as well as by citizens of another state. I do not think that this extends to her. They say that 11th Amendment immunity extends to arms of the state, including state agencies, state officers acting in their official capacity. I think there's a strong argument she was not here acting in her official capacity. This is not what this is meant for, to put it bluntly, which is why we see a lot less argument from them on this. This is by the way, let's throw it in here. They say, as plaintiff notes in his complaint, defendant was at all relevant times acting as the clerk of court for the Circuit Court of Colton County, South Carolina, a position which she was elected. The Colton County Clerk of Court's office is funded by the state of South Carolina. Unquestionably, defendant then is being sued as an arm of the state. She has neither waived the protections of the 11th Amendment nor consented to suit in federal court. Accordingly, she is entitled to 11th Amendment immunity. Defendant is entitled to quasi-judicial immunity. Defendant is likewise, they say, entitled to quasi-judicial immunity. They're going through all of the various immunities, again, these are the oh, by the ways. Also, this and this and this and this and this. I don't even know if the court will get to this question. They say that because she was acting in her role, that, quote, the absolute immunity from suit for alleged deprivation of rights enjoyed by judges is matchless in its protection of judicial power. It shields judges even against allegations of malice or corruption. Judges. And ages ago, we looked at some cases where judges were doing things outside of their official role. And there are times where you are outside your official role enough. She was not doing the functions of her role. She wasn't checking in jurors and telling them to keep their hands off the thermostat. This was outside of her role. Quasi-judicial office officials whose duties are comparable to those of judges or prosecutors are likewise, they say, entitled to absolute immunity. And such immunity extends to the judge's subordinates for functions that are more administrative in character that have been undertaken pursuant to a judge's explicit direction. That doesn't apply here either. They go on to say, accordingly, clerks of court are generally afforded quasi-judicial immunity from suit or claims involving, quote, tasks so integral or intertwined with the judicial process that these persons are considered an arm of the judicial officer who is immune. So it's kind of tacked on to the judicial immunity. I could see this coming up in a circumstance where a clerk like misentered a birth date and somebody with the same name got arrested because a misentered birth date created a warrant for the wrong person with the same name. And then they're suing because they wrongly got arrested because of somebody's typo. I can see this coming up in that circumstance where you are doing your job, which is if you're the clerk of court and the judge has done the warrants for the day and you misenter it, that somebody might want to sue over that warrant being improperly entered. And you are functioning as a clerk in the role of issuing the warrants in the system. Or a circumstance where a clerk, I could see like a victim who was supposed to have a restraining order suing because the clerk didn't enter the restraining order or entered it in wrong. Those seem to be circumstances where this type of immunity for errors might apply because you're doing your judicial function and you're taking on the immunity of the judge because you're entering a warrant in for the judge or you're entering in a protective order or whatever. However, this isn't that. This isn't that. I don't know if the judge will get to this question, but this is not that. They are trying to extend that judicial cloak of protection to Courthouse Becky in her official capacity, but arguably talking to the jurors about the defendant's testimony is not within her official capacity and it's not within the judge of the job, so I do not think this will extend. But they are saying she's kind of under the umbrella. They also go on to say that she's entitled to qualified immunity, that even could plaintiff show that he suffered some constitutional deprivation, defendant is nonetheless entitled to qualified immunity. The Supreme Court held that government officials are shielded from liability in civil actions if their conduct does not violate clearly established statutory rights. Like jury tampering? And so then they are arguing that that would apply to Courthouse Becky's actions in this case. And they go through the case law on that. They say to determine whether a defendant is entitled to qualified immunity in this case, the court must make 3 determinations. So these are the questions you need to ask yourself. First, the court must identify the specific right allegedly violated by the defendant. Second, the court must determine whether at the time of the alleged violation, these rights were clearly established. Finally, the court must determine whether a reasonable person in the defendant's position would have known that their actions were in violation of another person's right. Ding, ding, ding. Would a reasonable person in Becky's shoes know that her actions were a violation of someone's rights. Bing, bing, bing. Kat Renix in the chat asked, how many different immunities does she allegedly have? She's alleging all of the different branches of different types of judicial immunity, essentially. I think that these are her weaker arguments. However, I can understand her lawyers being like, but she's a state actor. She's working in the judicial branch. I can understand why you try it. They're throwing everything at it. I think these are the weaker arguments. We're going to zoom through the rest of their very extensive. Did they get rights for extra pages? How are we on page 40? They're very extensive analysis of the law here, talking about where this applies. Look, we saw Clerk Rhonda come in and be like, you do not do this. Everyone knows that you don't do this. I don't think these are the strongest arguments. I don't fault the attorneys for making them. They are putting everything in here. They say that, quote, certainly defendant Hill's comments as alleged by plaintiff were less innocuous than the bailiff's comments in Green. So we're going back to the Green case that we've covered in other motions in this whole circumstance of Becky fuckery. They say that in that case, the bailiff's comments, which, though inappropriate, related strictly to the administration of the trial, but just as certainly they fell short of the comments at issue in other cases. They talk about whether or not jurors were prejudiced in these other cases and whether this case is more analogous to those. They are continuing through. I thought they were wrapping up. They're not. They are continuing through South Carolina cases. Here's their conclusion. The South Carolina Appellate Court found that those comments in other cases had no effect on the verdict of any juror, while the South Carolina Supreme Court held these statements were more than innocuous interventions. Upon presentation of these facts, astute analysis and diligent research, the former Chief Justice of the Supreme Court of South Carolina found defendants' actions did not rise to the level of constitutional violations. They're talking about Justice Toll. This is to say that in light of pre-existing law, the unlawfulness was not apparent. It's a nuanced argument. What they are trying to say is that the wrongness of Becky's actions have to be apparent to Becky, and even Chief Justice Toll could not find that her actions were a constitutional violation, which is why Chief Justice Toll, under the law of the land at the time in South Carolina, denied the motion for new trial. So if the astute, learned, wise Chief Justice Toll could not find that this was a violation of law, how's Becky to know? That's the heart of this argument. Because again, when we talked about this, we talked about whether or not South Carolina would shift their understanding of the standard for this type of violation, and they ultimately shifted the standard. They did. So the argument is very nuanced. I don't think it passes vibes. It's a very nuanced argument that the law actually did shift in its understanding to find that a new trial is warranted. But I think what shifted is not the understanding that Becky's actions were wrong. It was the understanding that Murdaugh did not have to present a certain level of evidence to then be granted a new trial. Again, very nuanced argument. But kudos to the lawyers for making it. I don't know if the court will get to these questions, but the lawyers, when we talk about lawyers literally splitting hairs, this is the type of thinly sliced legal argument that we are talking about. How could she plainly know it's wrong? Justice Toll denied the motion. The Supreme Court said that this took work for them to find whether a new trial was granted. Now I think there's room to finally parse it the other way. A good argument. I don't know if that's going to carry the day. I think the earlier arguments are more likely to carry the day on this motion to dismiss. But as we get to the end of this motion to dismiss, where are we? Well, 43 pages in of Courthouse Becky's kind of a deep dive into Courthouse Becky's motion to dismiss. And while the audacity of trying to claim different types of judicial immunity are not lost on me, the heart of Courthouse Becky's attorney's arguments are sound. The argument in its simplest form, and I don't want to do an injustice. There's plenty of injustice that's been done in this case. I don't want to do an injustice to the good legal work that has been done in this filing. But the heart of the argument is similar to what we see in food court, where we see the judges saying that the party doesn't have standing because there's no actual harm. Like, were you harmed because you had to let your microwave mac and cheese cool before you ate it, so it was therefore not ready in 3 minutes? This is analogous to the arguments being made here that Courthouse Becky's violation, if there is one, of Alec Murdaugh's rights is not what cost him attorney's fees. So the heart of that argument is that Murdaugh cannot recover for the attorney's fees for trial number 1 because the attorney's fees were not incurred because of Becky's wrongdoing. And then the follow-up to that argument is, if Murdaugh tries to argue that he's entitled to attorney's fees for trial number 2, that hasn't happened yet. That money hasn't been spent. And that question is not ripe for judicial consideration. It's too early. And I think that they have a very interesting argument that may carry the day on this motion to dismiss. Because truly, the harm done to Murdaugh on the attorney's fees is coming up, not the trial that's gone past. He would have spent that money either way. And I think that $600, right? I think that $600,000 was paid to his lawyers well in advance of any jury being selected, well in advance of Courthouse Becky saying anything to a single juror. And here's the pickle. Alec Murdaugh's lawyers in interviews have said, well, the job's not done. So we're still doing this trial based on the monies Murdaugh has paid us in the past. And if Murdaugh can't pay them for the next trial, does he have standing to sue Courthouse Becky for deprivation of his rights, not his lawyer's rights, his rights, if they are doing trial number 2 based on the funds paid in trial number 1? Because if he's not paying them anymore, then there's nothing to recover. There's no damages. And if there's no damages, then there's no case in controversy, because under 12b-6, the motion to dismiss is failure to state a claim for which relief can be granted. Is there any relief in Murdaugh's case that can be granted? And that's the question that the court's going to grapple with. And it's a nuanced question, but it's not as far of a long shot as we've seen in some motions to dismiss. This was a very thorough, thoughtful, and I think artfully lawyered 40-page motion to dismiss. And I find myself real interested in what the court's going to do and if the court's going to bring this motion to dismiss for oral argument, because I think this is the type of motion that we might see the court want to have oral argument on and question the lawyers a little more fulsomely. Because the attorneys for Courthouse Becky said, this is a question of first impression. EDB translation, we've not seen this type of fuckery before, Your Honor. We've not seen a case where someone is trying to get attorney's fees for a first trial because of what the clerk of court allegedly did, they say allegedly, I don't, during the end of that first trial. Because he paid that money to go to trial no matter what. It's a real interesting question. Let's take a look at what Murdaugh has to say, right? Let's take a look at what Murdaugh has to say, because that damages question, man, it's a real good legal question. And chat, thank you for letting me know what you think, because all of you were like, I see their point. Like, I see their point, right? And replay crew, let me know what you think in the comments. It is a legal question. Literally, it's got some meat on the bone. Let's see what the response is from Murdaugh. And that's what we're doing today. I am These are the types of cases that were so interesting in law school to go through and go over and be like, it's a really interesting question. And then Murdaugh ends up in this pickle of, but if you don't pay for the second trial, then there's no damages there. And if you try to argue that you knew about Courthouse Becky's interceding with the jury in the middle of trial and incurred more legal fees because of it, I don't think they can bear that out, because I think that $600,000 was paid in a lump sum before trial even started. And they argued in their motion for new trial based on newly discovered evidence that they didn't even know about Courthouse Becky's fuckery till after, fairly well after the trial had ended. So they can't even argue that they knew about it during trial. So then none of the monies paid during trial were because of Courthouse Becky, because they didn't even know. And if they're not paying for trial number 2, then there's no damages. What do you do if you're Murdaugh? Let's see. You probably say, this is outrageous. We bang the table. Let's see what Murdaugh is going to do. Filed July 2nd, 2026. Response to defendant's motion to dismiss. Plaintiff Richard Alexander Murdaugh, through his undersigned attorneys, submits this memorandum in response to the 44-page motion to dismiss. Excuse me, Your Honor, it's too many pages. It all comes back to Hamilton. It's too many damn pages for anyone to understand. Your Honor, it's 44 pages long. What's the TLDR? Okay, give us the TLDR. In response to the 44-page motion to dismiss of defendant Rebecca Hill, Ms. Hill's motion to dismiss does not and cannot deny what the Supreme Court of South Carolina has held unanimously. Oh boy. They're not attacking the stance first, are they? They're not attacking the case, they're attacking the person. Ms. Hill's motion to dismiss does not and cannot deny what the South Carolina Supreme Court has held unanimously, that Ms. Hill, then the elected clerk of court, sworn to protect the jury, instead secretly tampered with it and thereby stole from Mr. Murdaugh his constitutional right to a fair and impartial jury. Having, quote, placed her fingers on the scales of justice for personal profit, Ms. Hill now asks this court to hold that she may do so without consequence. She cannot. Your Honor, this is outrageous. How dare she? Because she sucks. Well, I don't necessarily disagree, but she makes some good arguments. They say Ms. Hill's motion is a make-weight damages motion masquerading as a motion to dismiss. Pound the table. We've gone directly to pound the table. It barely engages the elements of Murdaugh's 1983 claim. Oh no, it only attacks the one it needs to attack. If no damages, then no lawsuit. No, it doesn't attack the other claims. It narrows in with a laser-like focus on the one that's most likely to get this yeeted. Damages. And they argue damages like 3 different ways, including standing, which other federal courts in other cases have found persuasive. No damages, no standing, no lawsuit. Bye-bye. But Ms. Hill's motion is a make-weight damages motion masquerading as a motion to dismiss. Who loves the alliterations in this writing team? Is it Poot? It barely engages the elements of Mr. Murdaugh's 1983 claim. Well, right, because obviously the Supreme Court found that there was fuckery afoot and gave him a new trial. Why would they spend their time arguing that? The Supreme Court said it pretty heavy-handedly. So they go on to highlight that the heart of Murdaugh's claim is that a state actor, Becky, acting under color of law, being elected, deprived Murdaugh of a federal constitutional right because those elements are well pled. Instead, the motion attacks a single measure of compensatory damages and asserts a trio of immunities. These arguments fail for three reasons. Oh, do tell me. First, a dispute over one item of damages is no basis to dismiss a well-pled constitutional claim. However, if relief cannot be granted, then can yeet is the thing. First, a dispute over one item of damages. You have no other item of damages. What are the other damages? You can't say he's held in custody longer because of this case, because that's not true. You can't say he's being held in custody now longer because of the case, because that's not true. They say that nominal damages independently sustain this action regardless of the proper measure of actual damages. But Your Honor, obviously he was damaged in some way, so nominal damages apply. Hold on. What damages are pled in the complaint, me asks. Emily, that you said that weirdly. I did. Let's pull this up real quick. We're going to zoom this. I'm pulling up, for all of you listening in the background, I'm pulling up the complaint that was filed on May 17th. We're going to the very bottom of the complaint where their prayer for relief is encompassed. Their prayer for relief is that a judgment against defendant Becky in this matter in a sum sufficient to adequately compensate him for damages suffered, for punitive damages and reasonable attorney's fees, for the cost of this action and such other fees and relief as may be deemed proper. So their argument is that other damages the court deems necessary and other damages suffered are going to carry the day. They're saying because there could be some other type of damage, then this is fair. What do they plead in their cause of action? They have one cause of action, deprivation of rights. That Murdaugh had a right to a fair trial. That Murdaugh suffered monetary damages of $600,000. And that Ms. Hill's conduct was motivated by evil motive or intent and involved reckless or callous indifference to Murdaugh's federally protected right. Murdaugh is also entitled to recovery of attorney's fees under 1988. I think that was thoroughly dispatched. What other damages are they saying here? Punitive damages? Can you get punitive damages on a 1983 claim if there's no other damage? Excuse me. Can you carry the day on only punitive damages? Not if there's not other damages, you can't. Oh boy. But the opposition starts with banging the table. That Ms. Hill asked the court to hold that she may do so without consequence. She cannot. They say that the motion attacks a single measure of compensatory damages and that nominal damages independently sustain this action, which means any kind of scintilla of damages can sustain this. I mean, there is going to be no, it's a federal question, so you wouldn't even need the $75,000 threshold. But it's interesting that they're going to, but Your Honor, any damage.
Emotional damage.
We've now gotten to vibes. But Your Honor, vibes. Obviously, there's damage. And look at what they're doing next. They say the arguments fail for three reasons. First, a dispute over one item of damages is no basis to dismiss a well-pleaded constitutional claim. Nominal damages independently sustain this action regardless of the proper measure of actual damages. Second, the constitutional violation was decided by the South Carolina Supreme Court, but damages wasn't an element that the South Carolina Supreme Court had to decide. Under 12b-6, The second part of 12b-6 is that relief can be granted. If there's no relief here, then there's no cause of action. In the South Carolina Supreme Court, the relief was the new trial. They then say, therefore, in the absence of any further development of the record, the court should abstain from entertaining Ms. Hill's harmless error arguments. Give us more time. Give us more time. Hey, Your Honor, even if you're persuaded, hold off. Hold off on entertaining it. They say that the arguments are too fact-bound to consider in a motion to dismiss. Hey, Your Honor, just slow your roll, please. Third, at this stage, the court must accept the complaint's factual allegations as true, and these allegations plainly establish Mr. Murdaugh's standing to bring a claim against Ms. Hill. Here's the nuance in that. Do you see how Becky Hill argued it? Here's the nuance of that. The court has to accept the assertion that the $600,000 in legal fees is what was spent. But the court may make a factual finding that even if that's true, the $600,000 in legal fee that was spent was not spent because of Becky Hill and was not caused by Becky Hill. That's not a factual determination, that's a legal determination. And the courts are allowed to make legal determinations at the motion to dismiss stage. We've seen it a couple of times. And so they are asking the court, hey, this factual allegation should carry the day. Becky Hill is arguing, right, but the law does not connect the two. Even if the $600K is true, the law doesn't connect that to what Becky did. They say that Ms. Hill's asserted immunity defenses fare no better. The 11th Amendment does not bar damages claims against Ms. Hill in her individual capacity. Quasi-judicial immunity does not shield a clerk's own unauthorized criminal jury tampering, conduct the trial judge would have forbidden had he known it. I don't disagree with that. And qualified immunity is unavailable because the illegality of a court officer deliberately tampering with a jury in a criminal trial has been clearly established for at least 60 years. Poot's like, I was here when the law was written. Surprised he didn't say it. Your Honor, at the trial of Aaron Burr, sir, he actually did argue that to the South Carolina Supreme Court. If you didn't watch my coverage of that, it's a moment. Poot enjoys the theatrics. And because Ms. Hill's deliberate, concealed, profit-driven misconduct is an obvious violation by any measure, the motion should therefore be denied. What are they leaning into in the framing of their argument? Hill bad. Behavior bad. Behavior big bad. Bad behavior. Obviously, Your Honors, this is fine. But also, just hold on till later. Hold on for one more day. Right. Hold on till later. Just time out. Don't do it yet. Don't do it yet. Statement of facts. The following well-pleaded facts are taken as true for the purposes of this motion. We know. I love that they say, well, our facts are well-pleaded. In January 2023, Mr. Murdaugh stood trial in Colton County for the murder of his wife and son. Surprised they didn't say pawpaw, honestly. Miss Hill was the elected clerk of court and, as, quote, the officer of the court charged as the primary caretaker of the jury, was entrusted to shield the jury from outside influence. She did the opposite. I'm not reading their citations to their motion. I'm just going through their findings. If I take issue with any of their facts, I'll let you know. So far, checks out to me. They say motivated by a desire to write and sell a book about the trial because, in her words, she needed a lake house. I also think she wanted to be popular. Like, just by observing all of this, Becky wants to be everybody's bestie. I mean, she'll talk mad shit about you behind your back. That's my vibe. That's just pure speculation. But based on everything we've covered, she wanted to be the power broker in that courtroom. She wanted to be important. She wanted to be everybody's bestie. She wanted to have the power to be like, you can come in the courtroom, you can't. Loved it. She also needed a lake house. Do you remember when they were doing their overly gratuitous press conference after Murdaugh was convicted or after the sentencing? I don't remember which day it was. That Becky Hill was standing up on the staircase and Creighton was thanking Miss Hill and she was just like, oh, shucks. It was nothing. It's all good. Yeah, exactly that. She needed a lake house. Miss Hill believed a guilty verdict, quote, would be the best way to sell books, and she set out to obtain one. To that end, Miss Hill made repeated improper communications to the jurors she was sworn to protect. She told them not to be fooled, confused, thrown off, or convinced by Mr. Murdaugh and his defense, instructed them to watch him closely and look at his actions as he testified, and told them the day he testified was epic. I think she said was going to be epic. The thing is, at the heart of all of this, it just kind of stinks of Becky not trusting the jurors. Looking at them and being like, they're not going to understand. They're going to get fooled by the fancy lawyers and the big words. How offensive. To think that you're, what, the one that needs to guide them? Juries figure it out. It sounds like a few of them clocked your shit quite quickly. She didn't like that either. Can't wait till all that gets unsealed, but that's for a different day. They go on to say she held secret, repeated, private conversations with the foreperson and instructed jurors they could not ask about them. Yeah, anytime somebody, look, if you are ever on a jury and somebody's like, you can't ask about that, find someone else who works for the court, ask about it immediately. If you are on jury duty and something feels off or concerning, do not think that it must just be you and that it must just be fine. Ask. Ask questions, ask someone else. Because so often when we have that little, this doesn't seem right, so many of us just assume it must be me. I must be interpreting it wrong. No, it's not you. Trust yourself. Ask the questions. Because the worst thing that's going to happen at the end of the day is the judge is going to kindly say, oh, no, that's fine. Remember, the jurors that we've seen interviewed by Nate Eaton from Corey Richins' case asked about the fact that there was like a drone following them because they were like, that's weird. That seems odd. And the court staff or the judge, I don't remember which, said to them, that's our security protocol to make sure no one's following you. And they just explained it to the jurors because the jurors asked the question. I know so many of you grew up with like, sit down, be quiet, stop asking so many questions. I know. Try to uncork it. If you are on jury duty and something feels off, ask, because we have seen jurors time after time say, I thought that this was just the way it worked. I didn't know. I didn't know I could ask. I thought it was the way it worked. I wasn't sure. If you're not sure, just ask. Always ask. And remind yourself of every judge that we have seen. I think there's only been one that didn't profusely thank the jurors for their time. Remember how Judge M every time thanked the jurors, apologized to the jurors, and said, we are here for you. Thank you for the service that you are doing to this court. We need you, not the other way around. So please know that if you are ever on jury duty and something feels off, just ask. That extends to other areas of life, but just ask. They want you to ask. Write a note to the judge, ask the bailiff. If the bailiff is the one that's the vibes, find another bailiff, ask someone. Probably not asking your other jurors because then you're having a conversation about the case. Ask someone that works for the court and they will let you know. What you cannot do, and I speak from personal experience, what you cannot do if you have a needling question, and that question is, hey, I wonder if the prosecutor on this case is single. That's a question you don't need to ask. Don't ask that one. That has to wait till after trial. Keep those are inside thoughts. Hey, I'd sure like to ask the defense attorney out on this trial. Had that trial too. Don't ask. Hey, I'd sure like to know what shoes that prosecutor's wearing. Don't ask him. Don't ask him. That's gonna uncork a whole bunch of problems. Yeah, don't do that. Don't do that. So, I jest a bit, but if something seems off, like you can't ask about these questions, one of my philosophies in life, if somebody is saying you can't ask a question about this, what do I immediately want to do? And what do you immediately want to do? We want to ask. Of course we do. All right. Rant over. Good work, everybody. Good work about it. Good work, everybody. Lyndon, yes. Ask about the shoes and water bottle after trial. Exactly. Then you can ask those questions. All right. Doctor Who says, what if the attorney you want to ask out is hot? Irrelevant. Has to wait till after trial. Has to wait till after trial. There was a DA that I worked with who got married to one of the jurors from his trial because she shot her shot after the trial was over. It worked. They got married, have beautiful children. Waited till after trial. Waited till after trial. He Gives Beauty for Ashes says, who got followed with drones? The Richens jury. They followed them from parking into court with drones to make sure no one was following them. So, continuing on. They say that Courthouse Becky fabricated a Facebook post, interrogated and lied to a juror about it, and manufactured a pretext to have that juror who, quote, had not made up her mind, removed. Here's what I give credence to on that, is because how would Courthouse Becky have known that that juror had not made up their mind yet about Murdaugh, to go to the lengths that she seemed to go to get that juror removed if she wasn't having these improper conversations? This is one of those, the thing speaks for itself for me. Because I think we've kind of well sorted that the whole Facebook posting shenanigans were in fact shenanigans. But why? If Becky didn't know what that juror was thinking. And how would she have known that without those conversations? The actions, the behaviors, it all kind of points to the fact that that's true for me. I can't wait till all of that is unsealed. I want to see it. On May 13th, 2026, we were doing other shit. Sentencing Corey Richens, the Supreme Court of South Carolina unanimously reversed Mr. Murdaugh's convictions and remanded for a new trial, holding that Ms. Hill's jury tampering violated Murdaugh's right to a fair trial by an impartial jury. The court found that Ms. Hill clearly advised the jurors to find Murdaugh and the evidence he presented not credible, and essentially urged them to render a guilty verdict. And that her, quote, breathtaking and disgraceful effort, I'm using breathtaking in way more sentence. This is coming back into my vernacular because it's come up in a couple courts now. Siren song of something other than Starbucks, the breathtaking whatever, coming up way more. That her breathtaking and disgraceful effort to undermine the jury process is unprecedented in South Carolina. Separately, Ms. Hill pled guilty to perjury, obstruction of justice, and misconduct in office arising from her conduct surrounding the trial. Okay, to be fair, the misconduct in office was for theft from state child support funds. So I don't know if the misconduct in office squares with that, but I don't take issue with the rest of it because the perjury, yes, should have been prosecuted for jury tampering. Mr. Mr. Murdaugh funded his defense of the tainted trial. Tainted love immediately. Tainted, yes, the tainted trial. I love it that they're not calling it the first trial. It is now the tainted trial. That's a turn of phrase I'm not mad at all. I lost my place being excited about the tainted trial. Hold on. Where did it go? Damn it. How did we lose it? There it is. Mr. Murdaugh funded his defense of the tainted trial with a $600,000 withdrawal from his 401k retirement account, his sole remaining asset. Because Miss Hill corrupted the proceeding, that money purchased, the convictions were vacated, and the expenditure was lost. I don't know if that's compensable, though. They've tried to frame it better, but Your Honor, it was because of her behavior. The trial that we bought and paid for, we didn't get to keep. She spoiled it. Now we have to do it again. We ain't got no money. Legal standard. We know the legal standard. All facts are taken in the light most favorable to the non-moving party, here Murdaugh. But the court may make findings of law. We know that. We've covered it a bunch in food court. If you've not watched any of our food court, go back and watch where we talk about standing for not having any damages. We've talked about it a couple times. It's, I think, a great illustration of how this plays out in other cases. The complaint states a claim under 1983, regardless of the proper measure of actual damages. I think they're probably worried about this. Do you see the language they're using? They're trying to kind of minimize the arguments made by Miss Hill. Look the other way, Your Honor. Her behavior is breathtakingly appalling. We'll figure out the damages later. Don't concern yourself about the damages. We'll figure out the damages later. Like, shh. Later, we'll do it later. Don't worry about it. Look over here. Hill's motion is built almost entirely on the premise that Mr. Murdaugh cannot recover $600,000 in criminal defense fees. Attorney's fees. Yeah, they do. But even if that were correct, they say it is not, it would not warrant a dismissal. Yeah, it would. If relief can't be granted, then you don't have a case in controversy. Then you can't have a cause of action. Then you don't have a case because you only have one cause of action. So I disagree with that premise. But they say that even if that's true, it doesn't warrant a dismissal. A motion to dismiss tests the sufficiency of a claim, not the availability of a particular remedy. If there's no remedy, if no relief can be granted, then there's no claim. And there's no case in controversy because it's civil. That is just not correct. Wrong answer. A motion to dismiss tests the sufficiency of a claim, not the availability of a particular remedy. They go on to say the complaint pleads every element of a 1983 claim that Miss Hill, acting under color of state law, deprived Mr. Murdaugh of his 6th and 14th Amendment rights, and Miss Hill does not seriously contend otherwise. That alone defeats the motion. I disagree. I applaud that they are trying to shift the narrative to, but we have stated a claim. Damages don't matter. If no relief can be granted, no claim. I'm repeating myself because they keep trying to shift the argument, and I don't know if it will be successful. Northwest asked, costs for appeal on tainted jury have been incurred? No. It's a good question. Murdaugh does not plead for the cost of appeal. And I think the reason Murdaugh does not plead for the cost of the appeal is because, one, he would have appealed whether Courthouse Becky interceded or not. He just wouldn't have necessarily won. And two, that that $600,000, I think was already spent before they got to appeal. I don't think if they went to discovery, I don't think they would be able to show that Murdaugh paid for the appeal. So I don't think they could show any damages because of the appeal. And they were going to appeal anyway. I think it would even have to be limited beyond that to the second motion for new trial only. Because the first motion for new trial was going to be made either way and had nothing to do with Courthouse Becky. The second motion for new trial, if Murdaugh had to pay for that specifically, which I don't think that he did, then that second motion for new trial based on Courthouse Becky would have to be parsed from the other appeal because both appeals went to the Supreme Court and they were direct appeals to the Supreme Court. So we didn't really have to fight to get there. So I think it would narrow down to just that second motion to dismiss. I don't think he paid for it. I think the $600K was already gone and there was nothing more. So how are Poot and Jim paying for any of this? Or are they just taking the loss? I don't know. But I think that's why they didn't argue it. And I think that's why they can't argue it. Sis Bud said, what will happen with the money if Alec wins? Well, if Murdaugh wins, and if Courthouse Becky pays, it will go to the lawyers because they are narrowly parsing it as attorney's fees. So it's not money that would go back to Murdaugh that would then have to go to his victims. It's attorney's fees that would go to the lawyers. They are asking specifically for their attorney's fees, not for compensation to Murdaugh, and I think there's a reason. So if he won, which I think is unlikely, and if Becky Hill paid, then to the lawyers. Yentel Day says $600,000 seems like a lot for the defense they put on. I don't think so, given the costs of prosecution, including things like travel and housing and the rest of it, and the cost of the experts. I think it was probably all spent. Canonical Heat, thank you so much for the 50 gifted memberships. That's 2 of y'all that gifted 50 memberships today. It's incredibly kind and generous. Thank you. Welcome new members. There's like a flood of memberships. Hopefully today was your day, Law Nerds. So no, I don't think 600,000 is a lot for this type of case. The other argument is, honestly, if he can't afford his attorneys, Murdaugh has the right to rely on the public defenders. And we have seen his attorneys, and I don't remember which one was talking about it, but we've seen his attorneys already start to cede to the court that they don't have money for hiring experts this round, and they are going to need the court to open up some defense funds for them to hire experts. And I'm real curious what's going to happen with those arguments, and if South Carolina will allow like a hybrid appointed attorney where you then get state funds. Or if South Carolina is going to say, okay, well, if he needs state funds, then he needs the public defender's office, and then y'all are out. I'm real curious. They go on to say that Miss Hill attacking the measure of compensatory damages, even that they're trying to distance. They're not saying it's the relief. They're just saying it's how you measure the damages. It's being measured by attorney's fees. Attorney's fees aren't the relief being requested. No, it's just how we're measuring the amount of money. Ms. Hill's attack on the measure of compensatory damages in this case is premature and not cognizable under a Rule 12b motion because nominal damages are available under 1983 upon proof of a violation of an absolute constitutional right without any proof of compensatory damages. And what they are relying on now is that nominal damages can keep a claim alive. So they are saying there is relief that can be granted because nominal damages are allowable under a 1983 claim. I'm real interested to see what the court does with that. They've only got one quick cite here from a 1978 and then reiterated in 2021 case saying that nominal damages redress a completed constitutional violation and sustain a live claim. But it's real quick. They say Ms. Hill's own motion concedes this, quibbling only that the complaint did not expressly invoke nominal damages, even though controlling Supreme Court and Fourth Circuit authority does not require a specific prayer for nominal damages in the pleadings. And then they're going through the case law saying that, look, we can have nominal damages, which makes this different than like the food court claims, where you can't really have nominal damages that are not directly pinned to a specific thing to compensate you for an attorney's fees, a doctor's bill, a dent to your car, or whatever it is. These are damages that are allowed because a harm's been done. Obviously, there's some damage. We're allowing for some nominal damages so that this can go forward, which is an interesting quirk to this being a constitutional violation. But it might not save the day down the road. But it might. I think this is a really interesting question. They go on to cite another case, Farrar versus Hobby, holding that a 1983 suit obligates a court to award nominal damages when a plaintiff establishes the violation of his right to procedural due process, but cannot prove actual injury. Your Honor, we don't have to prove actual injury. We have nominal damages available to us, so we don't have to prove attorney's fees as the injury. We don't have to prove compensable damages. They go on to say that punitive damages are also available in a 1983 action, even in the absence of proving compensatory damages. If that's true, that might carry the day a little bit. Hey, Your Honor, we don't have to have any compensatory damages at all. Punitive damages are still available. If true, that's why we would see them leaning into, but what she did sucks, Your Honor. She can't just get away with it. What the fuck? Punitive damages, the punishment ones. Even if we don't have any other damages, those damages still exist. And isn't this the kind of case where punitive damages mean something? Your Honor? Your Honor, so wise. So wise. Even though we don't have these types of damages, these types of damages are available. If that's true, it's going to be an interesting question that you can have punitive damages exist where no other damages exist. Curious to see. I'm curious to take a look at that case. That's a 2016 case with a Westlaw site, but not a reporter site. I wonder if there's no other case that says that. I'm really curious about. Though it says it's citing a Supreme Court case, I'm interested in the legal research on that side of it. We're not going to deep dive into it today because, as I said, EDB has some time crunches today. Then they go on to argue. Their first argument was, did you notice their first argument? I think their first argument is their strongest, right? Their first argument is, hey, nominal damages are allowable even where there's no compensatory damages. And even if nominal damages to the side, compensatory damages to the side, punitive damages still exist. Therefore, there is relief because punitive damages, I would argue punitive damages aren't relief, they're punishment, but there are then damages. We then can move forward. It's an interesting argument. And that's their strongest argument. They make it first. Murdaugh's legal fees are recoverable under 1983. I think Becky Hill has made a strong argument that they're not. They say that Hill opens her argument with a mischaracterization of the issue as being novel. Only the factual predicate for Murdaugh's claims that Ms. Hill's shocking jury interference for personal profit is novel. They say there's nothing novel about a claim for attorney's fees incurred because of a state actor's violation of defendant's civil rights. The case that they're citing from the Seventh Circuit says, quote, expenditures for legal representation during the period or during the prior criminal proceeding most assuredly constitute economic harm. The reasonable amount of these expenditures, if proved to the jury's satisfaction to be the consequence of appellant's illegal conduct. Isn't that the question? Is Murdaugh's legal fees from trial number 1 the consequence of Becky Hill's action? And I think the answer is no. And even in the case most friendly to them, from the circuit split on this, I still think their argument fails because I do not think it's the consequence. Here comes the consequence. I really want to be able to say that to Becky Hill too, though. Look, here comes the consequence. I really do. But I don't think this is the scenario. I don't. They go on to say Ms. Hill correctly quotes from a district court in the Fourth Circuit stating that the Fourth Circuit has never directly addressed whether a 1983 plaintiff can recover attorney's fees incurred in connection with the underlying state criminal proceeding. But Ms. Hill fails to inform the court that Judge Quarles went on to hold that, quote, the weight of the above described persuasive authority favors the allowance of the recovery of attorney's fees incurred during the underlying state action as an item of damages in a 1983 suit, provided that the plaintiff demonstrates that the attorney's fees were a quote unquote natural consequence of the unlawful conduct, even as stated there. Is the attorney fee that Alec Murdaugh paid to his lawyers before this trial even started a natural consequence of Becky Hill's actions? I think that defaults back to no. Second trial is, not first. Even the case law they are citing as most favorable to them undermines their argument in this. They say, well, different minds, we've gotten to reasonable minds may differ in paragraph 3. They say, thus, while different minds may disagree about the measure of damages in this case, there is nothing novel whatsoever about a claim for attorney's fees as damages for a violation of constitutional rights. They completely ignored the arguments about whether or not their expenditure of legal fees or Murdaugh's expenditure for legal fees is a consequence of Becky Hill's action. They tried to reframe it and sidestepped it altogether. And now they go into the line of argument regarding Fourth Amendment searches and seizures. They've moved on completely. They've moved on completely to, hey, we shouldn't follow the way that the Fourth Circuit sees this. But even as stated above, you still have the language of, is this a natural consequence? It's not. They have an uphill argument here, which is why they argued first, punitive damages, am I right? Nominal damages, am I right? That's why that was first. They go on to say Murdaugh's pleaded theory of damages is loss of the value of his defense expenditure, not causing the prosecution. I mean, I'm trying, Your Honor. Ms. Hill's causation argument attacks a theory the complaint does not advance. Mr. Murdaugh does not allege that Ms. Hill caused his prosecution. The state's decision to charge and the grand jury's indictment are beside the point. For that reason, Murdaugh does not allege that Ms. Hill caused the upcoming trial of those indictments, and that is why he does not seek recovery of costs of defending the upcoming trial. His injury is the $600,000 he withdrew from his sole remaining asset to defend a constitutionally fair trial was rendered worthless because Ms. Hill corrupted the first attempt at a trial, forcing its vacator. Forcing it to be remanded? Forcing it to be vacated? Really? So they are trying to now split hairs that the value of the trial that he purchased was nullified because he has to go to trial again. So they're not asking for the costs of trial number 2. They're entitled to recover the cost for the asset that she diminished by causing the trial to be vacated. I don't think that's going to fly. They're trying. They're trying to nuance the same side of a coin, though. And again, all of the case law has some type of causation, which is why they put the nominal argument first. Because I think if anything carries the day on this, it's going to be the nominal damages or punitive damages. It's not going to be this. They say this is a wasted expenditure injury that flows directly from Ms. Hill's conduct, not from any third party. Mr. Murdaugh paid for a defense at a fair trial, but Ms. Hill's conduct, because of Ms. Hill's conduct, he did not receive it. There's nuance in that argument. I don't know if it's going to fly, but there's nuance in that argument. They say the but-for chain is straightforward. But for Ms. Hill's tampering, there would have been no constitutional violation, no vacatur, no forfeiture of the value of Murdaugh's defense expenditure. Over here, Your Honor, look over here. Mr. Murdaugh must defend a constitutionally fair trial because the state chose to indict him. Ms. Hill did not cause that. Because Ms. Hill secretly tampered with a jury in the state's first attempt to try the indictments, Mr. Murdaugh was also required to defend a trial corrupted by Ms. Hill. The state did not cause that. I don't think that reasoning is going to fly. But they're trying. Notice it's a lot of argument and no case law citations? Correct. Your Honor, we are not seeking the money for the new trial because they can't do that. We're not seeking attorney's fees. We're seeking the loss of value of the money paid for the first trial because we didn't get a constitutionally fair trial. So the money that we paid to defend a constitutionally fair trial, we didn't get the value of it because we have to do a second trial, but we're not asking for the money for the second trial because we can't do that yet. Mr. Murdaugh thus must defend 2 trials, they say, one corrupted by Ms. Hill and another one caused by the state's obligation to replace that trial with a fair trial of the indictments. Ms. Hill, therefore, is liable to him for the actual cost to Murdaugh of defending the unnecessary trial she caused, the first trial. Do you agree? Do you agree that the unnecessary trial was the first one? They're trying to back it up. Back it up. You had to do the first trial no matter what. It got vacated. Now you got to do the second one. The second one's the problem, but you can't sue for the second one. So you're trying to make the first one the issue. The first one was going to happen no matter what. No matter what Courthouse Becky did, the first one was going to happen. You got a second one because of Becky, not the first one. The first one you bought and paid for yourself. A for effort, but we're not getting very far down the road on this. Murdaugh must defend 2 trials because of Ms. Hill's actions. So Ms. Hill, they say, is liable to him for the actual cost to Murdaugh of defending the unnecessary trial she caused, the first one. The upcoming second trial, which will cost significantly more than the first, is the necessary fair trial caused by the indictments. You cannot just flip it and be like, see, Your Honor? Gone full Missy Elliott. We put that thing down, flip it, and reverse it. Was it worth it? Let me work it. What are we doing? The Olympic level gymnastics, we have finally found them. We have found the Olympic level gymnastics, y'all. Here it is. We are literally backflipping over to make the first trial the one that's the problem, and the second trial just the one that they're not asking about. No. A for effort, but no. Ms. Hill caused the need for the 2 trials to occur. But the additional trial she caused is the first trial. You can keep saying it, you can put it in italics, but you're not going to make fetch happen. We're not making fetch happen on this one. Keep putting first trial in italics. But Your Honor, the first trial is the problem. Even Billy Flynn's not making this happen. Sorry, Poot. I appreciate the effort. You had to try it. They say the first trial is a legal nullity with a vacated verdict, not the more expensive retrial that presumably will result in a constitutionally valid verdict. Your Honor, we're not even asking you for the breathtakingly expensive one. We're asking you for the first one. I mean, no one's yet pointed out the whole press conference where you said that Murdaugh's not paying for the second trial, so you don't have any damages for that one, but I digress. Footnote 2. If the retrial is not for some reason constitutionally valid, the failure certainly would not have been caused by Miss Hill. Right, she's been yeeted. The foreseeability of the damages she caused is a jury question. Your Honor, don't kick it out yet. Give us more time. It is not likely a difficult question for a jury to find it foreseeable that secretly corrupting a 6-week trial for personal profit would cause injury to the litigants. For the new trial. They say that the constitutional violation is established and may not be relitigated in a motion to dismiss. And they didn't. I agree with this point, but they didn't. They didn't relitigate whether a constitutional violation had occurred. They litigated fulsomely whether a violation caused injury that relief can be granted for. So I don't disagree. They go on for pages and pages about it. They go on to say that Ms. Hill's 1988 argument's not responsive to any claim in this case. It is, because it's in your complaint. I'm switching to the complaint real quick. Complaint. Line 64. Mr. Murdaugh is entitled to a recovery of attorney's fees and costs under 42 U.S.C. 1988. They were just closing that loop. They say that Ms. Hill argues at length that criminal defense fees are not recoverable as cost under 42 U.S.C., but Mr. Murdaugh does not seek the $600,000 under 1988. He pleads it as compensatory damages. The complaint's 1988 request seeks fees Murdaugh incurs prosecuting this federal civil action, which is allowed. However, if this action's not allowed, then that's not allowed. I think they were trying to close all loops. They say Ms. Hill's challenges to Mr. Murdaugh's standing to bring suit are without merit. Whether the fee injury is traceable to Ms. Hill is irrelevant, but regardless, it certainly is traceable to her. If there's no relief that can be granted, then there is no standing. And there's no claim. But okay. They say that traceability is a requirement of causal connection between injury and the conduct complained of. Notice that they're not talking about but-for causation or proximate cause. They are shifting to a different standard that was not argued. They say compensatory damages are not an element of the claim, but relief is. Murdaugh is entitled to nominal damages. That might be the argument that carries the day. That if Murdaugh is entitled to nominal damages, that may be the one thing. They go on to say that Ms. Hill's theory that Murdaugh is entitled only to a pro rata portion of his defense cost from the time of the jury tampering mid-trial to the verdict is odd. And why Ms. Hill believes that argument could have any bearing on standing is incomprehensible. Inconceivable. When Ms. Hill's tampering actually began is subject for discovery. Whether damages should be $600,000 or $165,000 or some other number manifestly is not a question to be decided on a motion to dismiss, and certainly not a challenge to standing. Why Ms. Hill believes that tampering with a jury only corrupts a discrete fraction of the trial is difficult to understand. Well, I understand their argument. However, I understand where they are trying to sidestep the other actions. What they are saying is, Your Honor, the actual number doesn't matter. If there's damages, then there's relief that can be granted, then there's a cause of action, then we get past a motion to dismiss, then we all keep going. Because if this gets dismissed, because there's no relief can be granted, there's nothing they can do about it. They're kind of in a pickle. So they're trying to stay alive to fight later. They say Murdaugh's claim is ripe because the injury is complete. Hill's arguing that if anything, it's the cost of the next trial and that's not ripe yet. And they're saying, no, the first trial, Your Honor, the first trial, the first trial, the first trial. She tampered with the first trial. We didn't get the benefit of essentially the bargain on the first trial. And then they say no immunity bars this action. And we are not going to dive through their immunity arguments today. I think they're Hill's weakest arguments. I do not think there is a strong argument that Hill interfering with the jury is in any way connected to her official duties. It's, I think, clearly outside the scope. I do not know if the court will even get to these arguments. If the court gets the earlier arguments, they might not get to these as thoroughly. They are arguing that Hill is clearly acting outside any official capacity, and therefore she is so far outside the scope of her role that there cannot be immunity here when someone willfully and illegally interferes with a jury. I don't disagree with their arguments on this. We are not going to go through all of them because I need to get to questions. Their header number 3 in this says qualified immunity does not protect deliberate jury tampering by a state official because the right to an impartial jury is clearly established. Right. All right. So their conclusion is, Your Honor, please don't dismiss it. Deny the motion. Let us continue. But they do say, if the court dismisses, we request leave to amend. Please don't dismiss it with prejudice. And the only time we would see the court dismiss with prejudice is if the court finds as a matter of law, there is nothing that can be changed. The facts in this are the facts. And when taken all the facts as pled, they're going to take all the facts as true. If all of this is true, if the court finds that even if all of this is true, there is no relief that can be granted, then, well, as a matter of law, this can get yeeted. And then why would you amend it? Because there's nothing you can say. This is just a matter of law, like the Velveeta case. The nominal damages are something that we don't see in food court, and that truly might be the thing that carries the day. This is signed by Philip Barber. I'm not surprised. Philip Barber does a lot of their writing. Honestly, every time Barber stands up, I'm like, oh, good. We've entered the realm of logic and less hyperbole. I appreciate it. I appreciate Barber. I appreciate the nuance of the argument. They have some difficult arguments. Nominal damages might carry the day. So the defense went a long way to try to reframe that, Your Honor, it's the first trial that's the issue, because the second trial is going to be the one without the constitutional impropriety of tampering with the jury. The first trial we paid for, and then it got erased. It just got vacated. Well, vacator. It just got vacated off. It got obliterated, Your Honor. So we paid $600,000. It was obliterated. That's the trial we deserved. That's the trial that we didn't get. That's the problem. What could be more egregious, Your Honor, than Becky Hill interfering? But also, if we can't get the attorney's fees, we can get punitive damages if there's no compensatory damages. So punitive damages keep it alive. But, Your Honor, also, we're entitled to nominal damages even if we cannot prove compensatory damages. The argument that even if we can't prove that there is compensation needed, a constitutional violation under the law allows for nominal damages, and that is the flicker of light that keeps this cause of action alive. So please don't dismiss it. Thanks, Your Honor. I'm interested to see what the reply is, and I'm really interested to see if the court asks for oral argument on this, and very interested to see where the court goes, because this is not a cut and dry on its face argument. These are nuanced legal arguments. The defense goes a long way to try to reframe the argument, but it's really going to come down to whether or not there's relief that can be granted here, which is why the nominal damages may carry the day and keep this alive. Now, I wonder what happens as we get down the road on this. I'm curious to see. Look, Becky Hill's attorneys made some good arguments. There was a lot of pounding the table from Murdaugh's arguments because there are some good arguments by Becky Hill. But there is that glimmer of hope because if nominal damages carry it, then period, that's it. It keeps going forward. So I'm really interested in the legal work that's going to unfold here. I think there's going to be some very interesting legal fights. But I'm not surprised that Team Murdaugh leaned into, Your Honor, this behavior cannot stand. We cannot let her get away with it. You cannot just come in here and interfere with juries and then be like, well, it's the second trial that's the problem and it's not ripe yet. So come back later. Too bad. So sad. You cannot allow this, Your Honor. It cannot stand. I understand why. Because the gravity of what Courthouse Becky did is breathtaking in how horrific it is. But the legal question still stands, which is, can relief be granted? Can't wait to see what the court does on this. We're going to answer just a few questions, and then I have got to bounce, law nerds. What do you guys think on this? It's curious. Some of you have asked, and a number of you have asked, and we've gone through it a few times. We're going to go through it one more time. Why can't he just get the damages for the second trial? And I think the reason that they are not even trying to wait for that is because Murdaugh doesn't have any money to pay for the second trial. And if Murdaugh's not paying for the second trial, you can't be compensated for what you didn't pay. There's no compensatory damages there. Nominal damages would still carry, but there's no compensation if he's not paying for that second trial. That's why you don't wait for the second trial. Bold strategy on both takes. Interesting legal arguments. I am very curious. I like everything about this. I know some of you are like, Murdaugh, I hate it. I know, but it is really interesting. It is really interesting to see how this plays out. And I understand why the lawyers want the money back. And I do think Becky should at some point have to pay for all of the costs. I would just like to see that money go to the taxpayers of South Carolina. I know that Poot and Jim and Phil are doing a fuck ton of work. I have no idea how they're getting paid. Or if their firms are able to just absorb the cost of this case on other cases, which is a lot. But it's not like it would be the first time that Murdaugh cost those around him everything. Because it was other lawyers, it was his law firm, it was his clients, and ultimately, the state has alleged it was his wife and son. And those allegations are going to go to trial again. So, are we shocked that Murdaugh continues to cost those around him? No. No, we're not. MT said in the chat, these are great arguments, even though it seems unfair. This is, I think, going to be one of those cases where we are going to have the opportunity to step back and look at the law in kind of a detached way. I agree that Murdaugh, if he did this, should be prosecuted and should be in prison for the rest of his life, which he already probably is going to be on all the financial crimes. I think that there should be severe consequences for Becky Hill's action. Agreed. Agreed on all of it. And then we get to step back in the civil case and say, where is the right measure of compensation for this type of lawsuit? And it's going to be an interesting exercise in looking at the law in a fairly detached way, because there are some really good legal arguments here. And I think we're going to see some great lawyering. And we get to look at it in a more detached way. Everyone should get more punishment. However, do I think Becky Hill's ever going to pay Murdaugh's lawyers at the end of the day? I don't know if the money's there. Would I rather see Murdaugh's victims and the taxpayers get paid? Yes. Like, his lawyers are choosing to be there, and they're still choosing to be there. they feel that they are ethically obliged to do so, but they're still choosing. The taxpayers of South Carolina had no choice in this at all. His victims had no choice in this. So Murdaugh's lawyers are still choosing to be here. Becky Hill chose what she did. She didn't get prosecuted for it. So whatever the outcome is here isn't going to right the wrongs that exist outside of this civil case, which allows me to step back and say, let's see what happens, shall we? Because do I, at the end of the day, feel very strongly whether money that Courthouse Becky probably doesn't have should go to Murdaugh's lawyers? Not really. I understand why they feel strongly. Would I like to see other types of restitution? Yeah, I would. That's not what's on the table here. So now we get to exercise what is, look at what is, and see if what the law allows for matches the scenario we have here. Because the logical thing is, well, because the first trial got vacated, the second trial is where the damages lie. Right. It's kind of like when we talk about the bricks and minifigs case, and we're sitting there going, why didn't anybody just give the Lego back? Just give back the Lego. What are we doing? Why are we here? Same here. Just, what are we doing? All of you stop it. Of course you don't interfere with the jury like this. But Poot and Jim are still, choosing to be here. Do you think Barbara got a say? I'm so curious. Or do you think Barbara's like, is this what we're doing? All right. I think this fact scenario is very interesting. I would bring this to law students for sure. I would absolutely how do you parse this given the wide fact scenario we have? And in the reply, are we going to see any estoppel arguments? I think the lawyers were very careful to sidestep the arguments that they can't make, which I appreciate because we have seen way too much lawyerly misrepresenting lately. I appreciate the cautious sidestepping and the reframing. That's lawyering. You've got the, no, Your Honor, we're not looking for the second trial. It's the first trial. It's the reframing. It's the creative arguments. There is room for zealous advocacy without misrepresenting the record. The job of lawyering is to invite the court to see it from your perspective, not to rewrite history. And this case, I think, is a good example of the nuance in those arguments versus some of the other bullshit that we've seen. Rewriting history is not it. Inviting the court in. No, Your Honor, it's not the second trial. It's the first trial. This is why. So we'll see. I like it. I'm into it. I'm here. I'm here for the lawyering on this one. And of course, we're in for it with Murdaugh Part 2. They're not coming back to court until August, I believe. So we will, in August, in the Murdaugh criminal trial, learn more about how long it's going to take to get to trial. Tentatively set for, hey, this is happening April 2027. I don't do continuances. But the court is waiting for feedback on whether Murdaugh's attorneys, because everything is now becoming a circle of cases that we cover, whether Murdaugh's attorneys are going to be able to hire the lab that did the IgG in the Kohberger case. So Corey Richens' attorneys are citing back to Murdaugh. Murdaugh is citing over to Kohberger, and we'll find out in August what happens there. I've got just a moment to do a few questions. Huge thank you to everyone who gifted memberships today. Replay crew, don't forget, there are timestamps down below. So good to see you. Law nerds, I will be out and about this weekend. I will be doing my best to keep you in the loop if things happen in the cases. I cannot guarantee how well I will do that this weekend, but if I see stuff, I will try. And I will let you know in the app. Notifications went better today, so I'm optimistic. There are some updates coming to the app, and I worry that as changes were being made to updates, it was just a few steps of oh, wait, oops. Something went wrong. But I'm real excited for the updates that are coming because we are building in updates that are going to just make everything so smooth, and I cannot wait. But I'm very excited to go see Travis. And I think as we end today, Carrie spins. I think we need to answer this question for you. Carrie says, am I too old or too young? Who is Scotty? I think we try to go 3 for 3. Emily, reckless. I think we try to go 3 for 3 on a musical interlude here and share a little bit of Scotty Doesn't Know. So, from the classic film, let me pull this up real quick. We're going to the film. There is also a song. You can find the song. But we are going to the classic film Eurotrip with the bop Scotty Doesn't Know, which is sung in this movie in cameo. And it is a catchy little tune about, well, Scotty doesn't know that Fiona is got a little action on the side is the thing. So don't tell Scotty. Don't tell Scotty. Beth in Texas, I do not know if I will be able to get to Houston. So thank you to hubby driving for Crown, because that's amazing. I do not know if I will be in Houston. I will keep you guys posted on where I will be. I do not know yet if I will be in Houston. Our travel plans have continued to shift because we are working with Dr. B's back. So, fingers crossed. Replay crew. Look, replay crew. If this is the last you see of today, know that we had to cut out what happens next. Go look for Scotty Doesn't Know on YouTube. So, if we end here, thank you for being here. Thank you for being a Leonard. If it continues, yay. Emily, reckless with the, yeah, it's fine. Leonards are the best. Let's go. Thank you to everyone who gifted memberships today. This is Scotty Doesn't Know, brought to you by the Leonards and the amazing gifted memberships. So.
Hey, listen up, everybody. Got a little special thing I'd
That's
like
Scotty.
to do tonight. I'll play a little song for you about the nastiest, freakiest little sex puppet I know.
Okay,
Fiona.
try to overlook an age difference here. Just movie. Suspend the disbelief. Just the disbelief. Fiona.
This one's for you, baby.
This is, in fact, a graduation party.
Happy anniversary.
Happy anniversary.
Scotty doesn't know that
That Fiona and me do it in my van every Sunday. Sings with coach at church, but he doesn't go. Puts just on her knees. Scotty doesn't know. Oh, Scotty doesn't know. Scotty doesn't know. Scotty doesn't know. Fiona
says she's out shopping.
She's out shopping.
But she's under me and I'm not stopping.
Cause Scotty doesn't know. Scotty doesn't know. Scotty doesn't know. Scotty doesn't know. Scotty tells Scotty. Scotty doesn't know. Scotty doesn't know. I know. Poor Scotty. Scotty doesn't know. Scotty doesn't know. So don't tell Scotty. Right. Right. So rude for Scotty. I know.
I can't believe he's so trusting.
Right. You can imagine what comes next. So that is Scotty Doesn't Know. Look, it is a bop. It is. It is a bop. But then again, I grew up in the 90s when, Lips of an Angel was a song about romance. Look, it was the 90s. What are we going to say? Well, this was the early 2000s. Either way, Scotty doesn't know. Poor Scotty. Scotty didn't know. Scotty didn't know. Also, Fiona. He seems like a nice kid, girl. Eurotrip. That is Scotty Doesn't Know. So it is a song reference that constantly comes up when we are talking about whether or not somebody knows or does not know a thing. But That is the Scotty doesn't know. Scotty doesn't know. Don't tell Scotty, because Scotty doesn't know. So, Law Nerds, it's so good to see you. Thank you for being here. Thank you for being a Law Nerd. Thank you for the summertime musical interludes. They are needed. And Lyndon, you look, Lyndon, Flowers in the Attic was somehow elementary school reading. I don't know. When people look at Gen X and they're like, hey, y'all, I'm like, look, man. No one knew what we were reading. It's fine. I feel bad for the high schoolers today. We all know what books those are. I see you. At least you have a Kindle. I don't necessarily know what you're reading. But, yeah, elementary school reading. Was it? Probably not. Did we do it anyway? Did we read? Yes, we did. It was in the elementary school library. Scotty didn't know. Scotty didn't know. Don't tell Scotty. Don't tell Scotty. Law Nerds, you are the best. Thank you for being here. Thank you, Team Baker. It's been a long week of streaming. I will see you soon. I will be posting in the app. I have some stuff I can't wait to share that I am doing tonight, weather permitting, and then a very early flight tomorrow. So I will keep you in the loop on the journeys. Thank you again. And thank you, Team Baker, for a very long week of streaming. I will see you guys soon. Have a good one. And I will let you know if Flow Marching is streaming any of the Cavaliers this weekend, so you can go watch, or again, you can go watch on Funliner's channel. I can't wait. See you guys soon. Law Nerds, the Murdacity. It's going to be an interesting fight. I'm looking forward to it. See you soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.